The Royal Commission is now in session. Please be seated.
Mr. Scott, you're appearing with Miss Berry
I am for today's proceedings.
and Miss Hogendore, and you.
Commissioner, I appear with Mr Glover and Miss Nicholas for the Commonwealth,
Thank you.
and I will be in and out.
Right, thanks. And I understand you're calling Miss Fredericks first?
Yes, Commissioner, the order will be Miss Fredericks, Miss Lumley, then Miss Essex.
And just for the record, the hold-up was just while Miss Fredericks was being given the chance to look at some documents, I understand.
Yes, Commissioner.
Right, thanks.
Before Miss Fredericks is called, may I tender the exhibits for today's proceedings, which are numbered on a list I understand has been provided to your Associate Commissioner. They should be exhibits 4131 to 4205.
Commissioner, can I just confirm that's the exhibit list version 6, which should have the updated status of claims.
That's the one I'm looking at.
Thank you, Commissioner.
4131 you said, I'm just
Yes.
finding it.
Yes, Commissioner. It skips over
Got it.
some other evidence, but that will be corrected once that evidence is called later in the proceedings.
Right, so over to 4205.
Yes, Commissioner.
Those exhibits are admitted with the numbers that there. Thank you.
Commissioner, I call Anna Fredericks.
Thanks. Ms Fredericks, will you take an oath or an affirmation?
Pardon me. Affirmation.
Right, would you stand and we'll just have that delivered?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat. Yes, Mr Scott.
Thank you, Commissioner. Ms Fredericks, could you please inform the Commission your full name?
Anna Jane Fredericks.
And you received a notice to give a witness statement and produce documents dated 18 October 2022.
That's correct.
And you produced a statement in response to that notice dated the 21st of October 2022.
That's correct.
Are the contents of that statement true and correct to the best of your knowledge and belief?
They are.
Is this right, Ms Fredericks? You presently hold a position of Principal Legal Officer at the Department of Finance.
That's correct.
Your statement is principally concerned with a draft advice provided by Clayton Utes dated the 14th of August 2018.
Yes.
Thank you. At the time of that advice, you were employed as a Principal Legal Officer in the Social Securities and Families section of the Legal Services branch at the Department of Social Services.
I was. Yes.
Thank you. Were you previously employed at the department, previous to that time I'm saying, were you previously employed at the Department of Human Services?
I was immediately prior.
So what was the period that you were employed at the Department of Human Services?
Approximately March 2016 to September 2017. I was a executive level 1 lawyer with periods acting at the executive level 2.
And where did you work, or what area did you work in at the Department of Human Services?
Principally in privacy and secrecy law. So with restructures over time, it ended up being the program advice and privacy branch, but I was specialised in privacy.
Was that in the Legal Services?
Yes, sorry, Legal Services Division.
Who did you report to in that area?
Maris Steepniks.
Right, and who did he report to?
Varying over time, but for the vast majority of my time, it was Annette Mussolino.
Including in January to July 2017?
Yes, correct.
Thank you. During the early period of 2017, were you a lawyer embedded in a team responding to a Senate inquiry?
Correct, yes. We're
That team was led either by Jonathan Hudson or Jason McNamara at various times?
Jason McNamara for the period I was involved.
Okay. And separately to that, is this right, you had involvement in drafting responses to the Ombudsman for its inquiry in early 2017?
Correct, I had some input, yes.
That is the investigation by the Ombudsman into the online compliance intervention.
Correct.
Thank you. Could the witness please be shown this document, document ID CTH.3005002.3599, exhibit 1335. Commissioner, this is one of the new documents. Do you want a hard copy?
Oh, yes, please. Thank you.
Ms Fredericks, do you accept that's an email from yourself to a number of persons dated the 2nd of February 2017,
I do.
CCing amongst others Jason McNamara
Yes.
and Michael Robinson?
Correct.
Who was Michael Robinson?
My recollection is vague, but I believe he was another SES officer working in the compliance area, pulled in to work on OCI Robodebt as it had become at the time.
Did he also, in addition to Mr McNamara, had involvement in the Department of Human Services response to the Ombudsman investigation?
I believe so. Jason was the primary person overseeing the work, but I believe Michael had involvement as well.
Okay. And you see there that it says, "Hi team, I've populated my sections of the OMBO outline." See that?
Yes.
Text is distinguished in blue. Do you see that?
Yes.
And the attachment is outline of OCI own motion investigation report -AF. See that?
I do.
You've had an opportunity to read this document, that is this email and the attachment this morning.
Correct.
Do you have a recollection, having had that opportunity, of what the document that is attached to this email is?
A very vague recollection. I had completely, prior to seeing it this morning, it wouldn't have come in my memory that I had worked on this. But very vague.
And what is your very vague recollection?
I believe it was a document, an internal document briefing document to support responses to initial findings in the own motion investigation. So to support the department's view response.
Do you recall that it is a marked up version of a draft outline of the proposed Ombudsman's report into the online compliance intervention?
Now that you have raised it, I do. Yes.
Except that's what it is?
I accept that's what it is, yes.
And the text distinguished in blue constitutes your markings, your proposed markings on that document?
Yes.
That is proposed, in effect, response by the Department of Human Services to the draft outline provided by the Ombudsman, correct?
Yes, correct.
Thank you. And if we can go to the next document that forms part of the same exhibit, but document ID CTH.3005.0002.3600. It looks more like purple on the screen, but may we take it that coloured marking up constitutes your proposed markings?
Yes.
That is what you were proposing as part of the response by the Department of Human Services to the draft outline provided by the Ombudsman, correct?
Correct, yes.
Thank you. Now, did you have a practising certificate at the time?
I did, yes. Sponsored by the department, restricted government practicing certificate, yes.
Okay. And were you aware of the ethical obligations of a lawyer with respect to involvement in false representations?
Yes, broadly, yes. As due to my legal education, yes.
Right. And that is, it is incompatible with a lawyer's ethical obligations to knowingly be involved in a false representation, correct?
Correct. Yep, correct.
All right. And may we therefore take it that you satisfied yourself of the accuracy of the proposed response that you'd marked up in this document?
Yep, within the resources I had and knowledge I had at the time, yes.
Right. So what were the resources you had at the time?
So we were in a very small team, being pushed quite hard to respond to a very high pressure situation. So general resources you would be aware of. I had access to the internet, that sort of thing. I didn't have access or knowledge of legal advice that had been obtained by other departments into the development of the Robodebt matter. So at the time I was working on it, we didn't have the knowledge that of the use of income averaging as a primary source. The focus at the time, from recollection, was that the primary issue with the program was the data matching and the communication method. And so that was what we were focusing on.
Would you agree the usual way that a lawyer confirms the accuracy of representations that they are involved in is to obtain instructions from their client?
Correct?
Did you obtain instructions from anyone in the Department of Human Services as to the accuracy of what's contained in this document?
What I've populated in this document was based on information we were provided by the client, the department. So we had master talking points, a document from Karen Harfield, and my recollection is Dr. Karen Harfield worked in the program area, and there was a matter of public importance, which was a document that reports to the Office of Legal Services Coordination, and we were instructed to rely on those documents as our primary sources.
Right. So there was a master talking points document.
Yes.
It was utilised by the department in responding to any external inquiry about the online
Correct.
intervention.
Correct.
And you were under instructions to have regard to that in formulating this response,
Correct.
and you had instructions that it was accurate.
Yes, correct.
All right. Can I just call out, please, the second last coloured bullet point on the screen commencing with the words, "Nothing has changed"? You see that there,
I do.
Ms. Fredericks? See the words, "Nothing has changed"?
I do.
Did those words come from the Master Talking Points document?
They did.
Do you now accept that those words were inaccurate?
I do.
And in what respect were they inaccurate?
Broadly, I suppose because they are such a broad statement, at the time they were based on the understanding that it was the method of implementing the debt recovery program that was problematic, rather than the focus on the use of income averaging in the assessment of income over your fortnightly periods. And obviously, with the elapsation of time, it's quite clear that the process had changed.
And you accept that fundamental way in which the process had changed was that previously, if averaging was to be used at all, it was used as a last resort.
Yes, correct.
Whereas in circumstances where the department had failed to contact a recipient of Social Security, the default position was averaging was to be used, correct?
That's my understanding. I'm not specific.
There was also the fact they were now going back years. Where
Yes.
Before it had been a year.
Correct. There had been a 6-year limitation period prior to this.
And there was also the fact that people were being forced online.
Yes, correct.
Quite a lot had changed, really.
Just on the point about the change from using averaging as a last resort to, in effect, the default position, When did you first become aware of that change?
Later, when I was working in the Department of Social Services.
Right. So you weren't aware of that until then?
No, we legal services were, and I believe many people in human services were labouring under the assumption that it was a last resort. It had continued to be a last resort, or it was communicated to be a last resort, continued to be a last resort, whether in fact that was the case or not.
When you say it was communicated, by whom was that communicated to you?
In all documentation I received at DHS working on this, the program area primarily. I couldn't name an individual, but I suppose the messaging that we had received, or the instructions we received, was that while people were being encouraged or directed online to confirm their income, the attempts to contact them via letters, and we were under the understanding that there were a number of letters and compliance officers would call. Later becomes clear that perhaps calls weren't occurring and letters were not necessarily being received. We were under this understanding that there had been a number of attempts to contact the individual to clarify their earnings, and then income averaging would be used as the last resort with the input of the ATO data.
Were you aware that prior to the change, standard process was to attempt to obtain information from employers?
I'm aware that that's one of the mechanisms that can be used to obtain income information, yes.
And the department had available to it extensive compulsive powers to require employers to provide information?
Yes, I'm aware of that, yes.
Do you accept that it couldn't, on any sensible view, be regarded as using averaging as the last resort when those attempts to use those powers, or not even use powers, but attempts to contact employers were not being made?
I'd accept that now, yes.
Did it occur to you at the time?
It did not.
Is it the position that you simply accepted what you were told?
I would put that I accepted the veracity of what had been put to me on a complex program which I've not had any background or experience in, and trying to get across it in a very short period of time.
Right. Were you aware of any AAT decisions at the Tier 1 level in the first half of 2017 stating to the effect that the use of averaging in the way that it was being used under the Robodebt scheme was unlawful?
I was not. The AAT decisions were dealt with by the Freedom of Information and Litigation Branch, and program advice was never consulted on those matters or informed of decisions or outcomes.
Was Mr. Steepniks in any way involved in the Freedom of Information and Litigation Branch?
No.
Was it his usual responsibilities in any respect to be involved in AAT litigation?
No.
What was his main area of practice?
So we were responsible for, program advice, provided advice to the programs are the broad master programs of human services, so Centrelink, Medicare. There was an area of the branch responsible for advising, EL2 lawyers responsible for advising on the Health Insurance Act, the Centrelink programs, the delegations, all of those sorts of things. My part of the branch was responsible for advising on privacy and on occasion, the secrecy provisions contained in the Social Security law and more broadly. So it's more of an administrative law, statutory interpretation type function.
So can I understand your evidence to be that your role and Mr. Steepnick's role was mainly advising on administrative law matters?
Correct.
All right. And you would be familiar with the principles of administrative law relating to the lawfulness of administrative decision-making,
Yes.
including the principle that requires administrative decisions to be based on evidence?
Yes.
And you understood, did you, that a fundamental assumption that underpinned the use of averaging of ATO data is that, was that, the recipient had earned the income disclosing that data over in equal amounts over each fortnight?
Yes.
And did you understand that the way in which averaging was being used in the Robodebt scheme was in circumstances where there was zero evidence to support the assumption that that data was being, that income was being earned in equal amounts per fortnight?
Sorry, could you repeat that? Sorry.
Did you understand that the way in which the averaging was being used in the Robodebt scheme involved there being zero evidence to support the assumption that the income revealed in that data was earned in equal amounts per fortnight?
I wouldn't necessarily accept that there was zero evidence. The position that the department had taken was that the data matching that had occurred and the identification of the PayYG data was the basis of the evidence that had indicated the fortnightly earnings were inaccurate.
You accept, Ms. Fredericks, that one of the features of the law that justifies the attachment of legal professional privilege to the advice of government lawyers is their independence?
Correct, yes.
And so therefore, it was part of your role to form an independent view as to the law and not just accept the position put to you by the department, correct?
Yes.
So quite independently of what the department's position was, I'm asking you what you understood the position to be.
At the
Commissioner, can I just ask, I just want to assist the witness and also my learned friend. It's a little unclear to me what time period my learned friend is asking the question about. He seemed to move from the Ombudsman report, which is still on the screen, up to AAT Tier 1 reviews.
Fair enough. Are you talking about during the time of the Ombudsman's report? Or?
No, I should be clear, to be fair, up to the middle of 2017.
Sorry, could you repeat the question? I've been distracted, sorry.
Up to the point of the middle of 2017, did you independently reflect on the question of whether or not there was evidence to support the assumption that the data revealed, the income revealed in the AAT data was earned in equal amounts per fortnight?
My recollection is that I didn't turn my mind to that because at that point in time, my understanding was that the primary deficiency of the program was the communicative nature, moving to online, the lack of human involvement, perhaps the timing of letters going out right before Christmas, not the actual assessment of income.
Can I just ask a question here? Looking at that document, but at page 3602, if I can get you to go to the bottom of that page under analysis, Ms. Fredericks.
Yes.
You'll see the last bullet point which says that the Act refers to assessing applying income when it's first earned, derived or received.
Yes.
Then it goes on to say, but the practicality is this isn't always known and the department can ignore information or apply it in the best way available, which seems tantamount to saying if the Act doesn't provide for it, we'll find another way. Did that not trouble you as a lawyer? Well, first of all, I suppose I should ask you, do you agree it does seem tantamount to saying that? The Act doesn't provide for this situation, so we'll do what we can with what we've got.
Yes, I do.
As a lawyer, given that this is the exercise of legislated power by a department, doesn't it bother you?
Does?
Did it bother you then?
I don't have a specific recollection relating to this dot point, but I would comment that there were perhaps a number of things at the time that bothered me.
Isn't this your insertion? Isn't this the blue?
Yes, so it's my insertion pulling material from, so it's not necessarily my words. I've pulled material from other documents that we've been instructed to use to populate this document.
All right, thank you.
Just to complete the situation, the sequence of questions on this topic, Ms. Fredericks, would this be right? You didn't independently reflect at all on what you've been instructed about. And to be clear, in respect of this document, about what you've just been asked by the Commissioner.
I'd agree that it appears not on the documents. Whether I made comments in the workplace or verbally, and was instructed otherwise. But my recollection at the time, I honestly couldn't say hand on heart.
Was anybody else saying anything about this? What was the general feeling in the group you were in?
When I was pulled, context-wise, for this little team of people, there was a call to nominate EL1 type officers to go and work on this thing because there was a large, obviously it was a problematic program. There was a lot of media response, but the instruction within the department was that no comment was to be made, no responses without going through certain levels of clearance, using the master talking points, no variation from cleared lines. Certainly people were talking at a individual level, whether you would count that as a professional level.
Who was talking?
I'd say people on the floor in the building were making commentary, but it was largely focused on the substantive reaction. I think initially there was quite a surprise that there had been such a reaction to this program. Not necessarily around the legality of the methodology for income assessment.
Did any lawyer at the Department of Human Services express any reservations to you about the lawfulness of the program?
Not to me, but I would have not been in those discussions at my level.
And I think you mentioned a need to stick strictly to the master talking points.
Correct.
Except with specific levels of clearance. What levels of clearance?
It would have involved the secretary.
Catherine Campbell.
Correct.
And you understood there was a clear direction to stick to those talking points unless instructed otherwise by Ms Campbell.
Yeah, that's correct. It would have come, I wouldn't have been personally instructed by her, but it would have come down the chain of SES to us, yes.
And as a consequence, you did not feel able, is this right, to form any independent views about the accuracy of these talking points as a matter of law or fact?
Correct.
Thank you. That document can be taken down. Now, Ms Fredericks, are you aware of the Australian Institute of Administrative Lawyers?
I am.
Do you recall attending the Institute's conference in July 2017?
I do.
Do you recall a number of other Department of Human Services lawyers attended,
Yes.
including Mr Steepnicks,
Correct.
Mr French?
Yes. Many of us, in fact.
Yes. Do you recall Mr Hanks presented a paper?
Do.
Do you recall what he said in that paper?
Broadly. Very broadly.
Do you recall, sorry,
I couldn't articulate it, but I have a broad feeling for it, yes.
okay. Well, I'll take you to a document
Thank
that
you.
might reflect your memory,
Thank you.
refresh your memory, I should say. But you're aware of who Mr Hanks is, aren't you?
I am, yes.
He's now a King's Counsel by default, but at the time, of course, he was a Queen's Counsel.
Yes, correct.
A leading public lawyer in Australia, correct?
Correct.
Not infrequently briefed by the Commonwealth, in fact. You aware of that?
I wasn't at the time, no.
Okay. You're aware that Mr Hanks is actually the author of a textbook on constitutional law taught to lawyers in their undergraduate studies. Aware of that?
I wasn't. It was not the textbook used at my law school, but yes.
Fair enough. But in any event, you were aware that he was a well-regarded and respected public lawyer with extensive knowledge in administrative law.
Of course, and he was the keynote speaker at the event, so that would
Indeed.
indicate that, of course.
Thank you. Can the witness please be shown document CTH.3007.0006.7286. Sorry, Commissioner, I'm getting the exhibit number. It's exhibit 4141. Now, I appreciate, have you seen this document for today, Ms Fredericks?
I have not.
Okay. Well, I won't test your memory on it,
Okay, thank you.
especially because you're not a party to it. But I'm going to ask you whether it purports to provide some form of record of what Mr Hanks said at that conference, all right?
Okay.
So if we, and you can see that if we call out the email at the bottom of the page, 20 July 2017, 5:22 p.m. from Mr Steepnicks. See, it says, Peter Hanks QC's main lecture has commenced and an introductory remark suggests it will be quite critical of the department's actions re OCI. See that?
I do.
If we call out the next email on the chain. You see the later email from Mr Steepnick saying the main thrust is a suggestion that raising of debts using averaging is not consistent with the terms of the Social Security law. Further, that the law provides no scope to put the onus on the customer to provide information that they do not owe of debt. See that?
I do.
Do you recall Mr Hanks saying words to that effect in the presentation?
I do. I remember his focus was around the his opinion at that time that the scheme had reversed the onus of proving income or disproving a debt, and that being very critical of that.
That it had unlawfully reversed the onus.
Yes.
Thank you.
Yes.
Can we call out the next email in the chain? See, that's an email from Mr. Steepnicks at a later time, 6:02 p.m, stating these words: critical of Ombudsman's report for not questioning whether the process was consistent with the Social Security law.
Yes.
Do you see that? Do you recall Mr. Hanks making comments to that effect?
I don't recall those comments, but I don't doubt that that's the case if Maris has commented on it.
And that report, of course, is the 2017 report.
Yes, the own motion.
Yes. Go to the next email, please. 6:08 p.m. Mr. Steepnicks, critical of Secretary's characterisation of letters as merely clarification letters when customers are forced to engage or have debts raised against them. Says Secretary's statement in that regard is implausible. Again, suggests the process is not consistent with Social Security law. Again, critical of Ombudsman's report. See that?
I do.
Next email on the chain, please. Mr. Steepnicks says, ended by suggesting that someone should look to test the matter in the federal court. Do you see that?
I do.
All right. Now, we just bring that section of the email down and continue. You can see at the top, an email from Bevan Hannon. See that?
Yes.
Do you know who Bevan Hannon is?
I believe Bevan was in the media area.
Right. And
I believe, but that's a very recollection. I'm not certain.
okay. CCing Miss Mussolino.
Yes.
And you might have noticed the first email on the chain that started this chain commenced with addressing Annette and Kathy.
Yes,
And you understand Annette to be Annette Mussolino.
I do. Yes.
Okay. And the words in this email, appreciate the updates, Maris. Very helpful. We'll have to get you doing blogs next. See that?
I do.
Were you aware that during Mr. Hanks's presentation, Mr. Steepnicks was live messaging members of the department as to what Mr. Hanks was saying?
I was not.
Right.
I was not. I wasn't seated with him either.
Okay. Did you have any conversation with Mr. Steepnicks during the conference?
During the conference as a whole, yes, but following the keynote, which was the after-hour keynote, no, I did not.
Right. Did you at any stage after the conference have a conversation with Mr. Steepnicks about what Mr. Hanks said at the conference?
Not to my recollection.
Did what Mr. Hanks say at the conference raise any concerns for you about the lawfulness of the Robodebt scheme?
Yes.
Given who had made the presentation and the nature of the criticisms as to its lawfulness, it would have revealed to you, wouldn't it, that the Commonwealth faced very significant legal exposure and risk, correct?
Correct.
And that the sensible course at that stage on any view would be to get an independent legal opinion as to its lawfulness, correct?
That would be my recommendation, yes.
Did you, after the conference, make that recommendation to anyone at the Department of Human Services?
Not specifically after the conference. I'm certain there was commentary in discussions where I'm certain I had raised the prospect of getting advice at some point when I was at DHS on this issue.
Before this conference or after it?
I couldn't be certain, but likely after.
Right.
Likely after, given Mr. Hanks's commentary about looking forward to it being challenged, and I seem to recall he closed his remarks with he would be willing to run a matter pro bono as a test case.
What type of matter, did he describe the nature of the matter he would be willing to run?
I'd be looking for individuals with debts or debt claims.
And I think you said you suggested at some stage, you suggested to someone that an independent legal advice would be a good idea.
Yes.
Who did you suggest that to?
It may have been my colleagues, my peers, my EL2 peers, who at the time would have been Damien Brazel, or could have also been Maris. We were quite informal in our interactions, but I don't have a specific recollection.
Do you have any recollection at all of the reaction you got in respect of that suggestion? No specific recollection. Can you think of any reason consistent with the interests of the Commonwealth why, in the face of this presentation, the Department of Human Services wouldn't immediately get external legal advice?
The only reason that I could think of would have derived from the relationship of a parent department, junior department, with the relationship with the Department of Social Services. There was frequently tension between the two departments around advice on advice covering the Social Security law, given that that was owned by the Department of Social Services. So that would have been the only logical and reasonable barrier I would have, in my view, would have been that there would have been needed to be a negotiation and consultation between the departments, the joint responsibility for the program.
I see a joint agreement to get independent advice.
Yes, and who would source it and the development of questions.
Okay, well, can you think of any reason consistent with the interests of the Commonwealth why the Department of Human Services wouldn't immediately seek the agreement of the Department of Social Services to get independent legal advice after this presentation?
I cannot.
Okay. Are there any circumstances of which you are aware that might explain why that did not occur if it didn't occur?
Not that I'm personally explicitly aware of.
What was the general reaction to that paper? Because if you'd been under any illusions about what the problems were before, Professor Hank set them out, so you all knew. So what happens next? Nothing.
To be honest, I'm not sure what the general reaction was. I mean, there was discussion in my immediate area with my counterparts, noting that Maris was there and was aware of it. The normal process would have been the appropriate escalation process through the good old public service hierarchy of raising with the seniors and pointing out the risks. Through Maris, through Annette, then to our group manager, and then up to the secretary, and putting to her that there were substantial concerns, and obviously now we had a reputable legal counsel raising this publicly. Perhaps may have warranted further advice, but that would have been the normal. And given the nature of this program, in a normal matter, it wouldn't have necessarily needed that level of escalation up to the top, but given the nature of this matter and the instructions we had received, there was less autonomy, I would say.
Can you be a bit clearer about what you're talking about there?
For OCI at the time, it wouldn't have been possible within the department for an EL1 or an EL2 lawyer such as myself to independently and autonomously go out and outsource advice on the legality of the Robodebt program. That would have had to have been approved at a much higher level.
How high?
I would say at least, it would have at least gone, my understanding would have at least gone to Annette Mussolino. I'm certain Annette would have probably talked with Melissa Golightly, who was the program DepSec at the time, and Melissa would have spoken with Catherine Campbell. And if either of those parties had not been supportive, we would have been told very clearly or instructed not to seek advice.
See, Ms. Fredericks, what seems obvious is that by this stage, that is, as at the date of this presentation, there was a very substantial chance that independent legal advice would confirm that the Robodebt scheme was unlawful and so far it relied on averaging, correct?
If independent legal advice had been sought at the time and had full scope awareness of the program, I have no doubt they would have come to that view.
And if such advice had come back indicating that, that would have had catastrophic consequences for the program, correct?
Yes, it would have undoubtedly led to a redesign or a cessation.
Or substantial embarrassment to both the Department of Human Services and the Department of Social Services.
It would have likely caused reputational damage to those two departments, but also to the government.
And to the secretaries of those departments.
Likely, yes.
And to the program, the head of the Deputy Secretary in charge of the program, Ms. Golightly, correct?
Correct.
Thank you. That document can be taken down.
Did anybody ever come up with any sort of counter-argument to what Professor Hanks said? Did anybody offer any convincing rebuttal?
Not to my knowledge. There may have been discussions at higher levels where I'm aware of varying views on the assessment of income, or aware of varying views at the time, but not that I was party to.
Thank you.
Can the witness please be shown Exhibit 4142, Doc ID DSS.5093.0001.0314_R. And could we please call out the second last email, next one up in the chain from Ms. Lumley, dated the 9th of July 2018. You see that, I appreciate you're not involved in this email chain, Ms. Fredericks, but you see that's an email from Ms. Lumley.
I do.
Paul Dowling.
Yes.
Who's Paul Dowling?
At the time, Paul Dowling was an EL2 in the debt policy area of the department. I think at the time it was called the Payment Integrity Branch.
Okay. And it refers to a request for advice from Allyson. Is that Allyson Essex?
Yes, I would assume so, and particularly going on that spelling.
And a request that advice be formally sought from the AGS about income averaging. And then the question is asked whether it's in the context of a particular appeal or more generally. See that?
Yes.
Now, the name of the appeal is redacted, but given the context and the subject matter of your statement, you know what that appeal is.
I do, yes.
Okay.
And it's an AAT appeal.
Yes, AAT 1. So.
By this time you're in DSS?
Yes. Oh, yes, I moved across in September 2017.
And so you recall, obviously not this email, but about this time, becoming aware of a request for independent advice.
Yes.
Regarding the concept of income averaging.
Yes. I believe I became aware of it a couple of days after this when I received the request, yes.
And we just go down to the bottom of the chain, email from Miss Lumley to Miss Pulford, and it goes over the page. Have both parts of the email shown, or both parts out. This is some way back to the 12th of April 2018 from Miss Lumley to Miss Pulford.
Mm-hmm.
Miss Pulford was in the DSS legal unit at the time.
Yes.
By that stage, you were as well.
Yes.
And it refers to some articles.
Correct.
I'll ask for this document to be put on the screen. Exhibit 4206. Oh, sorry, it's not an exhibit yet, I beg your pardon. Doc ID is TCA.9999.0001.0036. And I have a copy for you, Commissioner.
Thanks. And do you want that made an exhibit now?
Yes, please, Commissioner.
Can it be 4206 or does it need another number? How's that going to leave everybody?
Yes, could it be 4206, please?
4206 it is.
Thank you. Now, Ms Essex, do you recognise that email? Beg your pardon, that article?
I don't recollect the article from the time, but I recall a number of media articles from the time that were critical, so
Okay.
I'm just quickly skimming.
Does its content matter or is it just the fact that it existed?
No, the content doesn't matter.
Okay, that's fine.
Did you know of Mr. Martin's writings at all? That's the journalist.
Yes.
He wrote a bit about averaging.
Not at the time, no.
Okay, thank
I
you.
wouldn't have identified him specifically, no.
If we could go back to the previous document, the email. Can you see the last hyperlinked document purports to be a reference to a UNSW law journal,
Yes,
and the name Carney is at the end of the hyperlink?
yes,
And you know what that's a reference to?
I do.
That's an article from Professor Carney,
Yes,
2018.
correct.
And that article also said that averaging as it was being used, words to the effect, averaging as it was being used
Yes.
under the Robodebt scheme was unlawful.
Correct.
And did you become aware of that article in April 2018?
Not in April, but certainly by July.
By July.
I was certainly aware of it by July.
And, all right, so by July you were aware of the article,
Correct.
and you were also aware of the AAT Tier 1 decision?
So I became aware of the Carney article and I won't use the name, it's been redacted, the AAT decision when I received the request for advice from Kristin Lumley. Prior to that, I was not aware of them because they hadn't been brought to my attention as the debt policy area was not one within my scope of control.
All right.
So the AAT1 decision had not been managed. It would have been referred to DSS for instructions on whether to appeal to the AAT2, but that was not a matter that I managed or had visibility of.
Can the witness please be shown Exhibit 117, Doc ID DSS.8.001.0001.5221_R? go to the email at the bottom of the chain, all out full of that email that goes over the page.
Yes, that's
You accept that's the same email we've been discussing, but in a different chain?
correct. Noting the later email, it was April that article would have been brought to my attention, correct?
It was brought to your attention in April
Yes.
2018.
The copy in, yes.
All right. So, when that article was brought to your attention in April 2018, did that affect your level of confidence in the lawfulness of the Robodebt scheme?
So specifically at that time in April, I can't recall, noting I was a copy in and the email was to my branch manager. I'm not sure that I would have immediately jumped to the article and read it or had time to do so, working on matters in my own space. But certainly, and I can't recall whether I read it in April or whether I read it later, but certainly I agree, once I read the article, yes, it did raise substantial questions for me.
Okay. So if we go to you said you became aware of the AAT decision
Yes,
in July 2018.
July or August when the request for external advice on income averaging was received, whichever date, I can't specifically recall. July, it would be July, yes.
I'll see if I can find the relevant email, Ms. Fredericks, but in the meantime, in reference to the AAT decision, can the witness please be shown Exhibit 4176, Doc ID DSS.5036.0001.0163_R. And you can see that's a decision of the AAT dated the 4th of May 2018.
Correct.
And if we go to the last page of that document and call out paragraphs 15 through to 17. See paragraph 15, it says, in summary, the Act did not authorise the calculation of youth allowance by reference to averaging of income in this case.
Yes,
And then if you look at the second bullet point under paragraph 17, the reference to the Terry Carney article,
yes,
except that's the AAT decision to which we've been
Yes.
discussing.
I do.
Now it's the case, isn't it, that when Tier 1 AAT decisions were made unfavourable to the position of the Commonwealth, there was a standard form advice provided by a DHS lawyer known as an AFAR.
Yes, correct.
Did you ever see the AFAR for?
Not until seeking this advice from Clayton Newts, and I actually had to go back to DSS to get access to it.
Right.
I presume the normal process, and this matter, my understanding is that DSS did confirm the instruction not to appeal. So the normal approach would have been that it would have come through and it would have been assigned to the EL2 responsible for youth allowance, which was Ms. Pulford at the time.
Sorry, I didn't catch that.
It would have been assigned to the EL2 responsible for youth allowance, which would have been Ms. Pulford, and then to a lawyer to manage the interaction with our policy client within DSS and to provide instructions. So the department, DSS and legal, definitely would have received the AFAR,
Right.
but I personally did not.
You weren't involved in that
No.
stage?
No.
All right, but you subsequently
subsequently saw it and reviewed it when seeking that advice from Clayton Newts, yes.
Right, about July 2018?
Yes.
Okay. Well, can we just look at the AFAR? Doc ID DSS.5036.0001.0008_R Exhibit 4179. Okay. Have you obviously the name of the case is redacted, but are you prepared to accept from me that this is the AFAR we're discussing?
I am, yes.
We can go to the second last page. And call out paragraphs 9 through to 11. I note in particular words in paragraph 10, the difficulty with this case is that DHS has been using a methodology that has and continues to be subject to criticism from a number of quarters. However, to appeal the AAT1 decision would be to put that squarely into the public arena. To successfully defend the approach, the various arguments mounted against the process would need to be addressed. There is otherwise a risk that the whole approach of the OCI would be undermined. And then in paragraph 11, an appeal is not necessarily recommended for the above reasons. See that?
I do.
Do you understand that to be a recommendation to not appeal a decision on the following bases? Firstly, the risk of adverse media attention.
Yes.
And secondly, the risk that the whole approach of the OCI would be undermined.
Yes.
You're familiar, of course, with the Commonwealth's model litigant obligations.
I am, yes.
Is that a recommendations that is consistent with the Commonwealth's model litigant obligations?
I would say not.
Why is that?
I would posit that it's quite clear that we've been put on, we, the Commonwealth, have been put on notice quite clearly that there's a question over the legality of the scheme in general, and reading that paragraph as a objective party, it looks quite clearly that it's the recommendation not to appeal is to avoid public attention of that concern, and that's squarely inconsistent with the model litigant requirements and the legal services directions.
Did a lawyer write that?
Yes, it would have been a lawyer. I'm quite shocked re-preparing and reading that.
Here, can you shed any light on this? Because, to put it charitably, everything I've seen suggests a certain passivity, is the kindest word I can use, on the part of lawyers who came across various aspects of the Robodebt scheme. What's the culture in, first of all, DSS legal that allows that to happen?
When I first arrived in DSS legal, it was a very siloed type of culture. You were responsible for what you were responsible for, and stay within those bounds. There was a strong view that, there appeared to me to be a view of, with some of the lawyers, that our role as legal, as a service provider to the department, was to provide advice on specific statutory interpretation, not to comment on, or not to necessarily explicitly not comment on, but perhaps it wasn't our role to turn our mind to broader risks than what was being explicitly asked. That definitely changed in the time I was there. I personally found that quite problematic. Changing in leadership, things did change. over time, I would note that ultimate leadership changed as well, and there was definitely pressure at varying points in time on what we did and what we commented on.
When you say that the leadership changed, for better or for worse?
We had some movement around early 2018 in branch management, and a new branch manager came in.
Who's that?
That was Melanie Metz.
That was
Melanie Metz.
Melanie Metz.
She after Alan Grinzel-Jones retired, she came in after him. They had some crossover. She was much more of a proactive lawyer, wanting to engage in programs from the start. We, unfortunately, being an internal in-house legal area, we weren't embedded in policy areas. We would only really be consulted frequently at the 11th hour on a very narrow part of a program, and we would be given a matter of hours or days to give advice, and we wouldn't have the full quantum of information, and even asking for more information, you wouldn't necessarily get everything that you would need. So she had a view to become much more engaged, and for example, we had some lawyers embedded in it. At the time we were standing up the redress scheme for institutional child sexual abuse. We had lawyers embedded with the policy program, and I think that was quite innovative at the time, and actually very good, because you can catch these things, you can catch issues around legality and program design at the start. But also other changes in leadership. We had a change in secretary with the former Human Services Secretary coming across to Social Services. And I would be confident in saying that over time, that, in my personal opinion, that was not a positive change in the culture.
Why is that?
My observation, and noting I was an EL2, not an SES, my observation that secretary could be quite controlling, had particular views and was not particularly keen or interested to hear views that did not support those views, her views, and there came to be a culture of, even at the higher levels, of reticence or fear to raise issues, or no one, colloquially there was a commentary, no one wanted to give her bad news.
Okay, I want to take you back a bit to the DHS legal section and the sort of advice it was giving, and the fact that the Hanks program doesn't seem to impel anybody into getting external advice. What's the culture there?
It was a very large legal practice. And I suppose the culture varied from branch to branch, to be honest, there. For example, in your the Freedom of Information and Litigation branch, there was a high, at the time that I was there, was a high proportion of contract lawyers, so non-public servant lawyers. That's partially impacted at the time by the ASL cap, I imagine, but we had a lot of agency lawyers coming in to do FOI and even managing RAAT matters. And that can have an impact on culture. Contract lawyers are not necessarily subject to your public service obligations, but also not that I would posit that any of them would be going out of their way to do anything poor, more that there's the lack of familiarity with public service, but also the departmental programs more broadly, like corporate knowledge.
So they'd be brought in on what, 12-month contracts or something with that?
Yeah. And elsewhere, I think we were doing the. I don't think there was. I don't want to represent it as a culture. No one was trying to avoid or do not to provide advice where advice was necessary. It was more we were under pressure from such a large department with such a large program base to respond to the requests we were receiving with the resources we had available. And I would say the resources were perhaps not resources, I mean people. At the time, while it was a large practice referred in comparison with other practices I've worked in the Commonwealth, I think generally legal practices are under-resourced in the Commonwealth, and service and outputs suffer as a result.
You could come to the view that certainly some lawyers in the in-house legal practices just provide the advice that the client wants.
You could form that view, yes.
How do you avoid that mindset? I mean, as a lawyer, you just shouldn't be doing that.
Yes, I think it's important to have strong leadership, ongoing education within the legal area. Strong leadership, from my personal perspective, I'm having an executive that's willing to, as I said, colloquially have your back when you're going against the push of the broader department, I think, is having strength and integrity at the leadership point.
By executive, do you mean head of legal?
Head of legal, head of, very rarely is your chief counsel a DepSec or anything like that. And so very rarely is your chief counsel a deputy secretary. So they're always reporting above. But in my view, they need to have a level of autonomy to be able and be respected to be able to push back.
Right, do you mean a general counsel reporting directly to the chief executive and having a level equivalent to a deputy secretary?
I don't know that that's necessary, but level pay scale-wise, I'm not sure. I don't think that matters. I think it's more about the mindset of needing to view in-house counsel as independent and there to, and the purpose of in-house counsel is to identify risks to the department and the Commonwealth and assist to deliver programs within legal frameworks rather than as a, I'm trying to think of a better way of describing. Rather, often we were viewed as a bit of a pain because we would raise issues, so some areas would avoid us. So ideally, having the independence and respect to be able, respect's not the right word, but authority to be able to give a view, an objective legal view that would, and confidence that the department is going to consider that. And then the third element I would put as being having a legal as an embedded component of all program design, not to develop a program or go to legal the day before the MPP is due saying that government has announced this measure. Can you approve it?
Are you referring to something specific in your knowledge?
Not something specific. It's just general. It's the general in government, in-house counsel, getting very little time to review matters and not necessarily being included in the development of a program or project from the start.
And your advice being sought at a point where the program is in a substantial stage of development and very difficult to walk back.
Correct. That's very, very common.
Because commitments have been made to senior people.
Very common.
And it's difficult then for people involved in the development of those programs to walk
Yes, correct.
it back. And therefore, people in legal, is this right, would feel pressure to provide the advice that's needed to get the program across the line.
Some could. The other view of that is that decision makers would take the view that the legal input is just one of many inputs that could perhaps be disregarded in light of their overall objectives.
Yes. When you were at the Department of Human Services, did you feel that the then head of legal services provided the necessary leadership?
Yes, I think she did. There were a number of responsibilities under her in the structure. So she wasn't just the Chief Legal Counsel, she had responsibility for other corporate functions, but yes, I do.
Did you feel supported by her,
Yes,
including to provide advice contrary to the interests of the department and its officers?
yes. It would have involved a discussion with her and a strategy on how to manage that, but yes.
Are we talking about Annette Mussolino? Or?
This is social services, I think you said?
I'm talking human services.
Oh, at human services, sorry.
We'll go back to social services. Who were you talking about?
That would have been Janine
Janine Richards.
Richards, yes.
Okay, going back to human services, same questions again, level of support.
No, I don't think so. I would say the access to leadership at DHS was not as easy to gain. A bigger corporate structure. And it may be due my level of confidence in being willing to attempt to raise something with the Chief Counsel may have been due at the time to I was relatively junior and new to the practice, so that may have some input to it, but certainly I didn't feel as much as though there was an open door policy, and there was definitely much more pressure from business groups on the legal practice.
Did you feel any pressure from Ms Mussolino at any stage during your time at Human Services to provide legal advice that would suit the desired outcome of the relevant program area that you're providing advice for?
Not pressure, no.
But not support to give advice contrary to the program area's objectives?
It's not that she did anything particular, it's just that I certainly, yeah. It was a culture that was more devolved, and perhaps you would have gone through your band one, so I would have spoken to Maris, and I definitely felt support from Maris to discuss issues. But Maris would have needed to raise with Annette.
All right.
Yeah.
That document can be taken down. I just wish to the witness to be shown Exhibit 4192, Doc ID DSS.5036.0001.0113_R. Please go to second last page. And you can see there an email from Ms Lumley dated the 11th of July 2018.
Yes.
And that's the request from Ms Lumley to Ms Pulford and yourself for the external advice.
Correct.
And if we go to the first page, perhaps don't need to call any specific elements out, but you accept, and perhaps, yes, you accept that there was, from that, a recommendation by you to get advice from Clayton Utes.
Yes. Correct.
And that recommendation was accepted
Correct.
and the advice was sought.
Yes.
It was obtained.
Correct.
It was purportedly in draft form, but you understood that it was unlikely to change in any way.
Correct.
And it was clear that averaging was unlawful.
Correct.
And to your knowledge, was anything done by the Department of Social Services to bring an end to the Robodebt scheme in consequence of that legal advice?
Not to my knowledge, no.
Thank you. Commissioner, that's the evidence of the witness.
We're running out of people. Ms Lucas, do you want to do this?
Apologies, Commissioner. I was just discussing something with Ms Hogan-Doran. Might I ask one question of Ms Fredericks? During your time, or Mr Scott asked you some questions, and the Commissioner asked you some questions about the culture within the legal services branches of both the Department of Human Services and the Department of Social Services. During your time there, were there any guidelines or protocols internally that dealt with situations where there were misgivings about policy proposals, or how any disagreement with legal advice was to be escalated within those departments?
Within Human Services, not to my knowledge. Within Social Services, we did have a practice manual, but that was quite outdated and was focused more on our service offering as an in-house service provider. Specifically, no explicit document on how internal disagreements were to be handled comes to my mind, no.
Thank you, Commissioner. The Commonwealth had no further
Is it
questions.
any better where you are now?
Yes.
Good to hear.
Yes.
Do you want Ms Fredericks excused?
May I please?
Yeah. Thanks, Ms Fredericks.
Thank
You're excused. We might take the morning break there and come back at 10:02, I think.
All rise. The Commission stands adjourned until 11:50 a.m. The Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Commissioner, I call Kristin Lumley.
Ms Lumley, will you take an oath or an affirmation?
An oath, please.
All right, could you stand?
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Take a seat. Thanks, Ms Lumley. Yes, Mr Scott.
Thank you, Commissioner. Ms Lumley, could you please tell the Commission your full name?
Kristin Leanne Lumley.
And you received a notice from the Commission to give a statement and produce documents dated the 21st of November 2022?
I did.
And you produced a statement in response dated the 2nd of December 2022?
Yes, I did.
Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes, they are.
Is this right, Ms Lumley? You're presently employed as Assistant Director, Task Force Integrity, Intelligence and Investigations Branch at Services Australia.
Yes, that's correct.
You've held this role since the 31st of August 2020.
Yes, that's correct.
Thank you. Between June 2015 and March 2019, were you Assistant Director, Payment Integrity, Payment Conditionality, Design and Policy Branch at the Department of Social Services?
Yes, I was.
And I'm going to ask you about a period between July 2018 and March 2019, a series of questions, in fact, about your line management during that period.
Yes.
Um,
Sorry, what were those dates again?
July 2018 to March 2019.
Yep.
I think you covered that period at paragraph
Yes.
16 of your statement.
Yes, thank you.
Is this right? Immediately above you in that line management was the person occupying the role of director for the branch, correct?
Yes, correct.
I apologise, I can't pronounce his last name. It's Mr. Philip
Mufarage.
Farage. Thank you. And then the next person above him was the branch manager for payment conditionality, design and policy, correct?
Correct.
Between July 2018 and 16 January 2019, the permanent occupant of that role was Miss Allyson Essex.
That's correct.
And of course, I'm distinguishing between permanent occupancy of that role and persons acting in that role.
Yes.
And further to that, from July to October 2018, Miss Essex acted as the group manager, the next level up, for the Welfare and Housing Policy Group.
Correct.
And at separate times during the period from July to October 2018, other persons acted in Miss Essex's substantive role, correct?
Correct.
Between July and August 2018, someone called Miss Roxanne Armstrong acted in Miss Essex's role.
Correct.
And then between September and October 2018, Mr. James Kemp acted in Miss Essex's role.
Yes.
After Miss Essex left the department on the 15th of January 2019, Mr. James Kemp acted as group manager from January to March 2019.
Mr. Kemp acted as branch manager and Mr. Philp was group manager.
Beg your pardon. I nearly got 10 out of 10. But in any event, regardless of whoever was occupying the role of group manager for welfare, housing and policy, that person reported to the Deputy Secretary for Social Security, who at that time was Mr. Nathan Williamson.
Correct.
And who in turn reported to the Secretary of the Department between July 2018 and March 2019, who was Miss Catherine Campbell.
Correct.
Thank you. The witness please be shown Exhibit 4142, Doc ID DSS.5093.0001.0314_R. I'm going to ask to be called out the second last email on that chain. That is the second last email that appears on that first page. Email Kristin Lumley to Paul Dowling, dated the 9th of July 2018. You recognise that email, Miss Lumley,
Yes.
as an email sent by you,
Yes.
referring to an understanding by you that in your absence someone called Allyson requested that formal advice be sought.
Correct.
And that someone called Allyson was Allyson Essex.
Yes, that's right. And
And the advice proposed was advice from AGS about income averaging.
yes, correct.
And is this right? You asked a question in the email, was this in the context of an appeal or more generally?
Yes.
And the details of that appeal are not revealed for confidentiality reasons, but you know what appeal.
Yes, I do.
It's a decision of the AAT. You recall when that decision happened?
I've reviewed my emails in preparation for this, and I believe it was around May 2018, May, yep.
Except from me, it was a decision of the AAT Tier 1 level on the 4th of May 2018?
Yes.
Okay, thank you. And we can go to it if necessary, but would you agree with me that you recall that decision specifically identified that income averaging as it was being used in the Robodebt scheme was unlawful?
Yes, it did.
And it referred to an article by a Mr. Terry Carney.
Yes.
Did you know at the time Mr. Carney had formerly been a member of the AAT?
I don't know if I knew that at the time.
Okay. But in any event, that article also identified that averaging as it was being used in the Robodebt scheme was unlawful.
Yes.
All right. You ask a question in the balance of the email. Sorry, before I refer to that, at the end of that email you state this: we considered this back in April below but decided not to progress. See that?
Yes.
And that's in reference to some emails at the bottom of the email chain.
Yes.
And the last email in that chain is an email from yourself to Ms. Pulford dated the 12th of April 2018.
Yes.
And that email commences with these words: "Hi Anne, as discussed with Phil."
Yes.
And that refers to a number of articles,
Yes.
including an article in the Sydney Morning Herald
Yes.
and Mr. Carney's article,
Yes.
all indicating views that the Robodebt scheme was unlawful insofar as it relied on averaging, correct?
Yes.
Thank you. Just want to ask you about the email later, that is the email from yourself on the 9th of July 2018, the comment that the issue had been considered back in April, but there'd been a decision not to progress it.
Yes.
Can you explain who made that decision?
I don't have a specific recollection of that. All I recall is that I didn't have the authority to request legal advice. So it would have been in discussion with my director at the time, Mr. Muffarage, and I don't know for certain, so I'm just speculating, and that he potentially would have had a conversation with Miss Essex. But I don't recall a specific sort of date, time, who was there. I just know that I didn't have authority to get the legal advice at that point in time.
Okay. Can I ask you about the next email on the chain? That is the email from Ms Pulford to yourself dated the 12th of April 2018 at 2:39 p.m.
Yes?
Pull that email out. You see there, Ms Pulford says to you, Kristin, the only general advice about the legality of the Robodebt approach we provided was the attached.
Yes?
And you recall receiving that email?
On reviewing my emails, yes, I was reminded of that.
Okay. Do you recall what was attached to that email?
I believe it was the 2017 advice that she drafted.
Or can we just call that up, please? It's Exhibit 116, DSS.8001.001.5219_R. Do you recognise that as the attachment to the email that we've just been discussing?
Yes?
All right. Just want to, and do you understand, had you seen this advice before, your recollection, before that email of April 2018?
Yes, I had.
Okay. And you're aware that there was an earlier advice, second counsel by Mr. Jones,
At this time in...
April 2018?
Yes, I became aware of that in early 2017 when the Ombudsman requested legal advices.
Right. And you're aware that that earlier advice from Mr. Jones, second counsel by Ms. Pulford, was to the effect that averaging was unlawful?
Yes.
Okay. And this is a subsequent advice,
Yes.
the 24th of January 2017?
Yes.
All right. Can we call out the words in the first two paragraphs? You see the question that's identified in the commencement of those two paragraphs is, you've asked about whether using income averaging as a last resort to determine a social security debt was lawful in circumstances where no other information about the person's circumstances are available.
Yes.
And the answer being given below that paragraph, with this proviso in mind, the answer is yes.
Yes.
Did you understand that that was the advice that the Commonwealth was relying upon to support the lawfulness of the Robodebt scheme?
Yes.
And did you understand that the Robodebt scheme was operating on the basis that averaging was being used where no other information was available?
Yes.
Even in circumstances, sorry, I'll start that again. Were you aware that the way that the Robodebt scheme operated, so that averaging would be utilised where no attempts would be made to contact a person's employer?
Yes, I was aware of that.
And no attempts were made to utilise the coercive powers available to the Secretary to obtain information from recipients' former employers?
Yes, that's right.
And you nonetheless understood, is this right, that in those circumstances, averaging was being used when no other information was available?
Yes.
Is that a belief you independently formed or a belief that you accepted based on what you were told?
I accepted that belief based on this legal advice.
Well, the legal advice comments on the lawfulness of certain conduct on certain assumptions. I'm asking you whether you independently formed the view that those assumptions actually were applicable to the Robodebt scheme as it was administered, to your knowledge.
Sorry, I don't really understand the question.
Well, the advice asks a question, or the advice answers a question about the lawfulness of using income averaging as a last resort. That is, in circumstances where there's no other information available. My question is whether you yourself formed your own opinion about whether or not the way that the Robodebt scheme operated, in fact, used averaging as a last resort, as opposed to just accepting what you were told about that.
I understood that it was not using coercive powers. That was one of the key components of the measure. And I understood that this was referring to when, like, last resort might not have been the best choice of words, that it was when there was no other information available to the DHS decision maker, no records, information on the customer's file, that then it would rely on averaging. It wouldn't take any other active steps.
Okay. I'm just trying to ascertain, Ms. Lumley, whether you reflected at all yourself on whether this advice was applicable at all to the Robodebt scheme when you became aware of it.
Yes, I thought this was applicable to the Robodebt scheme.
Okay, and did you form that view independently, or did you simply accept that it was applicable because you'd been told that it was?
Well, it had been asked in the context of the scheme and concerns around its legality.
Right. Okay. You're not a lawyer, of course, Ms. Lumley?
No.
Do you understand that when a lawyer gives advice in respect of a specific question, that question defines the ambit of the advice?
Yes.
And the specific question related to use of income averaging as a last resort?
Yes.
And doesn't that then limit the advice to being only applicable in circumstances where income averaging is being used as a last resort?
Yes.
And under the Robodebt scheme, it wasn't used as a last resort, was it?
I think the issue is that last resort isn't defined, and it was just a term that Emma Kate probably used without considering what that would mean. I believe the context was with regard to Robodebt scheme, which everyone had a fairly good understanding of how that worked.
Right. And
When you say everyone, do you mean everyone in DSS who had to worry about it, or who are you talking about?
DSS and DHS, yes.
How long had you had a good understanding of how it worked? Do you remember that?
I commenced in this team in June 2015, so it had already been announced in the budget at that time. And it wasn't an area of focus of my, nothing came up. DHS didn't approach us with any questions about the implementation of the measure. It was sort of just in the implementation phase. So I think it sort of came really to light maybe to me, to my attention, maybe 12 months later when I did some work on the recovery fee.
Okay, so that's mid-2016, is it? That
Yeah,
you understood how it worked?
basic understanding, yeah.
Okay, and other people in DSS presumably had a good idea too?
Yes, I would presume that my director at that time, Catherine Dalton, I believe was around from when it was first conceived. So I would have thought she would have had a better understanding of it.
Thank you.
Did you have an understanding of how averaging had been used prior to the Robodebt scheme?
No.
No. Did you have an understanding that prior to the Robodebt scheme, averaging would not be used until every possible means of obtaining the actual income information had been attempted?
Oh, I wasn't aware of that at the time, no.
Would you accept that that is a circumstance where averaging is being used as a last resort?
Yeah, I think that would be a better definition of last resort than this definition of last resort.
All right. We could go back to the previous email, please. So you ask, if we could go back to the email, your email at 4:25 p.m. on 9 July 2018. You ask Mr. Dowling for the specifics of what Miss Essex had requested so you could draft the request to legals. See that?
Yes.
And then if we go to the next email in the chain, or the last email on the chain, Mr. Dowling's response to you at 8:37 on the 10th of July. And you see Mr. Dowling does confirm that the request was made in the context of the AAT decision we've been discussing.
Yes.
And there's a specific statement that Miss Essex had said there was no urgency in respect of it. See that?
Yes.
Do you see the words at the start of the email? I thought this one might get your attention.
Yes.
What did you understand that to be a reference to?
Well, obviously, I can't speak for Mr. Dowling, but on reflection, I believe that's because he knew I very much wanted to get external legal advice, and sort of as indicated in that earlier in April, and I'd finally been given the authority to go ahead with it.
I see. So is this right? When the issue first emerged to you in April 2018, you very much wanted to get external legal advice at that stage?
Yes, I believe so.
Was that when it first emerged, or was it just bubbling about a bit more then?
It was bubbling about a bit more and getting a bit more like serious. I think the turning point for me was the Terry Carney article.
When did you first develop concerns regarding the lawfulness of the use of averaging under the Robodebt scheme?
I'd say real genuine concerns in April, but my initial concerns were raised in early 2017 when I first saw that 2014 advice that contradicted the 2017 advice. That was sort of a little spark of concern.
Did you discuss your concerns at that stage with anyone?
I believe I would have discussed it with my director at the time, yes.
Who was your director at that time?
Mr. Herman.
And what did he say in response?
I can't recall a specific conversation, but the general feeling at the time was that I think the department's position was that it was relying on the 2017 advice.
Right. So the 2017 advice and the 2014 advice are both internal departmental advices, correct?
Yes,
Not external legal advices.
that's correct.
And by external legal advice, we're talking about advice from someone or some body external to government.
No, I use the term external to the agency, so I classed AGS as external advice.
Sorry, I was terribly imprecise. External legal advice would include AGS,
Yes,
Solicitor General,
yes,
external law firm.
yes,
Wouldn't include advice from an internal legal unit within DSS.
no,
Wouldn't include internal legal advice from within DHS.
well, I guess technically they're external to the agency, but I would have always referred to that as DHS advice.
And the critical distinction is independence, isn't it?
That's right.
And you can get a greater degree of assurance as to the correctness of the advice if it's independent, correct?
That's right.
And as of January 2017, when I should be clear, is that when you became aware of the 2014 and 2017 advices that we've been discussing?
Yeah, it was either January or February 2017.
Okay. So as at that date, so far as you knew, the only advices were 2 internal DSS legal advices, correct?
At some point, I became aware of 2 DHS advices.
Okay.
I don't know what time frame. I don't know if I knew of them then or not.
Certainly no legal advices from a law firm?
No.
From AGS?
No.
From any barrister?
No.
Not the Solicitor General?
No.
And do you recall the media attention on the Robodebt scheme in early 2017?
Yes, that was when the inquiry was commenced by the Commissioner.
And
Ombudsman, sorry.
Ombudsman, yes. So you recall the Ombudsman investigation?
Yes,
You recall significant media attention about Robodebt?
yes,
You recall a Senate inquiry?
yes,
And in January or February 2017, you discovered there was no external legal advices,
yes,
particularly about the issue of averaging.
yes,
And the only advices DSS itself had obtained were 2 internal DSS advices,
correct.
and they were in conflict with each other.
Yes.
Is that a highly unusual scenario in your experience?
I don't know that I have enough experience with seeing legal advices on a similar topic. You don't often revisit something unless there's a different question that arises.
Did it cause you great concerns that the Commonwealth might be facing substantial legal exposure given the absence of any independent legal advice?
Yes, it did.
And so by April 2018, your concerns were starting to become quite significant
That's right.
in the face of the Carney article by Mr. Carney.
Yes,
And you sought approval to obtain independent legal advice at that stage.
Yes, as I said, I haven't been able to find something specifically in writing that says that, or can't recall an exact conversation, but evidenced by that email to Anne Pulford in April, that's my recollection, was that was exactly what I wanted to do at that time.
And your attempt to obtain independent legal advice at the time was declined.
Yes, but again, I can't identify a person. It's just a memory that I wasn't able to progress that.
But you could safely infer it would be someone superior to yourself.
Correct.
Thank you. We go please to Exhibit 4144, DSS.5044.0001.2430_R. All right, can we go to the advice on the top of the second last page? Sorry, the email on the top of the second last page, part of which is the bottom of the first page. Now, could that be taken down, please? Commissioner, I'm told that the version of this document has the name of the case, the AAT case, which we've been carefully redacting, but I'm told it won't be on the live stream, so it can be brought back up.
Okay.
That email on that document could be brought back up on the screen, please. That is DSS.5044.0001.2430_R, Exhibit 4144. While that's being brought up, Ms. Lumley, did you have an opportunity to look at the email when it was on the screen?
Yes, I'm very familiar with the email.
Yes, it's the email that was called out, that is 11 July 2018 at 12:43 p.m. Is that effectively you instructing Ms. Pulford and Ms. Fredericks to seek independent legal advice at that stage?
Yes, that's correct.
And then the next email in the chain was a response from Ms. Fredericks suggesting that advice be obtained from Clayton Utes,
Yes, that's right.
because AGS were under some pressure at that stage.
Yes.
That is volume of work pressure. And then Mr. Mafarage's response on the 12th of July 2018, sorry, it isn't coming up on the screen, but I trust you, as you say, you're familiar with the email, said, yes, we don't mind this going out to a private law firm if you feel it is appropriate, noting the measure that this relates to is very controversial and has already been implemented. Any advice will come under intense scrutiny. Is there a link between the fact that the measure was very controversial and had already been implemented and the proposition that any advice would come under intense scrutiny to your understanding?
Yes, I believe that's the connection that was intended.
Right. Why would it come under intense scrutiny?
Because there was questions about its legality in the public arena. And the opposition government, so that advice would be of interest to a lot of people.
From whom would you expect the advice to come under intense scrutiny?
The public and, the public, the media.
Well, the advice would be prima facie privileged and confidential, of course, because it's legal advice.
Yeah, I think more if we had to communicate what the advice recommended or what the advice, a summary of the advice, if we had to communicate that more broadly to the Ombudsman and, Senate estimates or that sort of thing, if it was contrary to an existing program that was up and running, then it would draw a lot of criticism.
Did you have an expectation that the advice would have to be communicated to the Ombudsman? Or at least a summary of it?
If they asked for it, which was likely given their continued involvement in it.
Okay. Could the document be taken down and could the witness please be shown Exhibit 1220, which is Doc ID CTH.3004.0010.5247? Do you recognise that document, Ms Lumley?
Yes, I recognise it, but I haven't read it for several years.
Oh, I'm not going to take you through it in chapter and verse, Ms Lumley. There's a specific attachment to it that I'm interested in, which I'm furiously finding. It's at page 52 of the document. Last four digits of the doc ID is 5301. Now, would you have read, you see that's a letter from Mr Pratt to the then Ombudsman?
Yes.
If we go to the next page, you see it's dated the 4th of April 2017.
Yes.
And if we go to the first paragraph on the first page of the document, you see there, Mr Pratt was thanking the then Ombudsman for the opportunity to comment on the report of the Ombudsman into the OCI system.
Yes.
In other words, the then iteration of Robodebt.
Yes.
Okay. And then if we go to the third paragraph on that page, you see the first sentence of that paragraph. The department is satisfied the system is operating in line with legislative requirements, and there have been no changes to the way in which DHS assesses pay as you go employment income. Do you see that?
Yes.
And you accept that that's a positive representation by Mr Pratt of his satisfaction that the Robodebt system was operating in line with legislative requirements?
Yes.
And would you, in those circumstances, expect that had the advice that was in contemplation in 2018 indicated that in fact it was not operating in line with legislative requirements, the department would update its position with the Ombudsman.
Yes.
And that is indicate that the department was no longer satisfied it was operating in line with legislative requirements.
Yes.
Thank you. That can be taken down. And is that a reason why it could be expected that an advice that averaging under the Robodebt scheme was unlawful would come under intense scrutiny,
Yes.
including by senior members of the department,
Yes.
because of the very serious implications it would represent?
Yes, that's right.
Thank you. Including by Ms Campbell, the Secretary?
Yes.
Do you recall at any stage during your time at DSS, whilst Ms Campbell was a secretary, of views being expressed within the department that Ms Campbell did not like getting bad news?
No, I don't think I heard that, no.
Did you have an expectation as to how Ms Campbell would react if the advice from Clayton Utes indicated that the scheme was unlawful?
Sorry, could you repeat the question?
Did you have an expectation as to how Ms Campbell would react if the advice from Clayton Utes indicated that the scheme, that is the Robodebt scheme, was unlawful?
I expected she would be very concerned if she heard that because she oversaw its implementation as the Secretary of DHS.
And are you aware of Section 8 of the Social Security Administration Act?
Not off the top of my head.
Okay. Do you generally accept that the Secretary of DSS would have an obligation to act on legal advice that the scheme was unlawful?
That would sound reasonable.
Thank you. Could we please go to Exhibit 4145, Doc ID DSS.5036.0001.0004_R. You see, if we call out the email from Ms Fredericks dated the 23rd of July 2018 at 10:11 a.m. to yourself, and there's a comment about Ms Fredericks apologising for the delay, having been in touch with Clayton Utes, who would be able to finalise the request for advice today. You see that?
Yes.
We go to the next email on the chain. See, that's an email from yourself. Hi Anna, we have just received a letter from the Commonwealth Ombudsman regarding an investigation into the department's implementation of one of the recommendations on OCI, and then the letter is stated to be attached. Do you see that?
Yes.
Thank you. And there's a question about whether there's a need to alter or expand the request for legal advice? By
Yes.
yourself? Okay. But I just want to take you to the letter. That is Exhibit 4157, Doc ID DSS.5099.0001.0003_R. Do you recognise that to be the letter that was attached to the email we've just been discussing, Ms Lumley?
Yes.
Okay. And if we call out the first paragraph. See there reference to correspondence from the Deputy Ombudsman indicating that there's the new phase of the investigation into the implementation of the recommendations
Yes.
from the 2017 Ombudsman report into the OCI system.
Yes.
See that? We go to, please, the third page of the document, last four digits 0005, and call out the heading on that page in the first paragraph. See the words there? The Ombudsman considers it may be open to the government to argue that the EIC process of averaging income is legal, but the legality of the system is not certain. The Office considers that certainty on this question can only be provided by a clarifying Act of Parliament or a decision by the Federal Court or High Court. Do you see that?
Yes.
And would you agree with me, based on your knowledge of the document, that what the letter goes on to suggest that there is a need for adequate and publicly available policy guidance regarding the circumstances in which inquiries might be made in respect of the use of information gathering powers. Accept that?
Yes, under the changes that they were recommending.
Yes.
Yes.
But that's all on the assumption that it's at least open to the government to argue that the system is legal, based on that paragraph that's called out there.
Sorry, could you repeat the question?
That proposal regarding publicly available policy guidance came after the statement that's called out there. Accept that?
Can I see the letter?
Yes. Yes, fair enough. Perhaps if we call out, put that section down, we call out the sections in the next two paragraphs in the section under the heading requested response.
Yes, I can see those questions come after the other paragraph.
Yeah.
Yes.
And they're those questions are made on the assumption, or those questions are asked on the assumption that it is open to the government to argue that the EIC process of averaging income is legal. Accept that?
Yes.
Right. And so this correspondence to the department sought a response based on that assumption.
Yes.
And if we call out the heading time, the section under the heading time frame, the response is requested by Tuesday, the 18th of September 2018. See that?
Yes.
And so that is when a response was requested by.
Yes.
Do you accept that between the date of this, the department, start that again, do you accept that between when the department received this letter and the expiry of the deadline for responding, if the department got external advice that the scheme was unlawful, it was incumbent on the department to provide an update as to its position regarding the lawfulness of income averaging?
Yes, I think that would be a fair statement.
Okay. That can be taken down. we please have up on the screen Exhibit 4147, Doc ID DSS.5044.0001.0176_R. And we call out the email in the middle of the page from Ms Pulford to yourself, dated the 14th of August 2018. Recall receiving that email, Ms Lumley?
Yes.
And do you recall that the effect of that email, and indeed the advice that was attached, was that averaging was unlawful?
That's correct.
And was there any ambiguity in your mind about that conclusion?
No, there wasn't.
We bring that down. We call out the email on the bottom of that page. Do you recognise this email?
Yes, I do.
Do you recall the comment in reference to the fact that the advice was provided in draft form, the indication from one of the lawyers that provided the advice that they might be able to rework the advice subtly if this causes catastrophic issues, but that there is not a lot of room for them to do so?
Yes.
Did you understand from that comment that it was, even though the advice was in draft form, the substance of the advice was never going to change?
Correct.
It was absolutely clear at that stage that the advice was and always would be that averaging was unlawful, correct?
In my opinion, yes.
Okay, that can be brought down. We go to the email at the top of the screen, same document. DSS.5044.0001.0176_R, Exhibit 4147. Last email in the chain on Wednesday, the 15th of August, 2018. Ms Lumley, that's an email from yourself to Ms Essex,
That's right.
the 15th of August 2018,
Yes.
forwarding the Clayton Utes legal advice to Ms Essex,
Yes.
specifically referring to the comments below
Yes.
and specifically communicating the advice to Ms Essex, correct?
That's right.
Now, and did you accept that advice as correct?
Sorry, which advice?
Or the legal advice, I beg your pardon, the Clayton Utes legal advice?
Yes.
Yeah, you didn't have any reason to doubt its correctness?
No.
Did you have any reason to doubt that all relevant questions had been asked?
No.
And did you understand that the effect of the advice was that the system of averaging that was being applied en masse by the Commonwealth to take monies from social security recipients was unlawful?
Yes.
Did you understand that there was a need to urgently brief the Secretary of the Department about this?
Yes.
Brief the Minister about this?
Yes.
Potentially Cabinet?
Yes.
Because of course it had whole of government implications, didn't it?
Yes.
Could you think of any reason why, sorry, I'll start that again. And of course, there had been the correspondence from the Ombudsman as well.
Yes.
And as you've agreed with me earlier, in light of this advice, there was a need to correct the position as to the department's understanding of the lawfulness of averaging with the Ombudsman.
I agree with that now on reflection. At the time, I'm not sure that I necessarily drew the connection between that letter, its due date, and I'm not sure at the time whether I put those two dots together.
Okay, all right. But you do accept now that in light of that advice, there was an urgent need to
Yes.
communicate with the Ombudsman about the new
Yes.
advice. And is this right? There was a new minister being sworn in at the end of this month.
I don't recall that.
Okay. All right. Can you think of any reason why the briefings to the persons and bodies that I've just earlier described, namely the Secretary, the Minister and potentially Cabinet, wouldn't happen as a matter of urgency?
Can I think of any reason why it wouldn't?
Based on your experience and knowledge of the workings of government.
It wouldn't be good news to share. It would damage the department's reputation, the minister's reputation. So, yeah, it would.
I'm sorry, Ms Lumley, I
Yeah.
was imprecise. I meant, can you think of any legitimate reason?
No, I absolutely thought that it should be briefed up as a matter of urgency.
All right. The witness please be shown doc ID DSS.5093.0001.0026, exhibit 4155. Seen that email before, Ms Lumley?
Yes.
That's a meeting invite for a meeting at Miss Essex office on the 21st of August 2018.
Yes, that's correct.
To yourself, Miss Armstrong and Mr Maffarage.
That's right.
Do you recall attending a meeting with Miss Essex and those other persons on that date?
No, I don't recall attending that meeting, but through searching my emails, I located that, and I also located another email that I wrote in September where I referred to attending that meeting. So based on that, I'm fairly confident that that meeting happened, but I don't have a recollection of it.
Okay. All right, well, could the witness please be shown exhibit 4159, DSS.5093.0001.0313_R. And email in the middle of that page could be called out, please. From Ms Lumley to Mr Kemp, dated the 10th of September 2018. Is that the email that you've identified referring back to a meeting?
Yes, that's it.
And you refer in that email to discussing the advice. See that? With Miss Essex.
Yes?
And you state that she said she would consider the issue further and speak to Nathan about it when the time was right.
That's right.
And may we take it that, given that you've said that in that email, that is in fact what she said
Yes.
on the 21st of August,
Yes,
2018?
I believe if I wrote that, that's what she said.
And the reference to Nathan is to Mr. Williamson?
That's correct.
What did you understand the phrase "when the time was right" to mean?
I don't know what that meant. Just that she didn't want to raise it with him now. That's, yeah, I don't know.
Surely the right time was immediately.
I would think so, yes.
And if we go up the chain to the next email from Mr. Kemp to yourself, dated the 10th of September 2018. Mr. Kemp says, "Thanks, Kristin. I was aware. I have a catch up with Allyson tomorrow when I will raise this." And your response then is, "Great, thanks."
Yes,
Did you understand as a consequence of that, you would take it up with her?
yes.
Okay. Now, if I could just ask you to make a mental note, Ms. Lumley, of the date, the 10th of September.
Yes.
Being the date that you sent that email to Mr. Kemp.
Yes.
Could the witness please be shown Exhibit 4162, Doc ID, DSS.5003.0001.0770_R. Now, Mr. Kemp's signature is redacted, but you can see that part of his signature appears there.
Yes.
And for the purpose of my question, I want you to assume this letter was sent on the 7th of September 2018.
Where did you get the 7th from? Oh, yes. This might help, Ms. Lumley, if we go to this document, Exhibit 4161, Doc ID DSS.5003.0001.0768_R. I just ask you to note, Ms. Essex, the date of the email at the top of that page, 7 September 2018, and what it purports to attach. Yes.
So do you accept from me that the letter that I just showed you was sent on the 7th of September 2018?
Yes.
Okay, thank you. If we could go back to the letter. Now, can you just read that to yourself, not aloud?
Yes, I read that.
Are you satisfied that it contains no mention whatsoever of the Clayton Utes advice?
Correct.
Or that the department's position had changed, that it was no longer satisfied that averaging as it was used in the Robodebt scheme was lawful?
Sorry, could you repeat that question?
It did not identify that the department's position had changed in that it was no longer satisfied that averaging as it was used in the Robodebt scheme was lawful. It had changed. It did not identify that it was no longer satisfied of that.
Yes.
Thank you. All right, can the witness please be shown Exhibit 4167, Doc ID DSS.5093.0001.0316_R? You recognise this email, Ms Lumley?
Yes, I do.
And you refer, the first email in the chain is an email dated the 20th of August 2018,
Yes.
addressed to a number of people, including Mr Maffarage,
Yes.
referring to a timeline,
Yes.
various legal advices,
Yes.
including the Clayton Utes advice.
Yes.
And then further email from you dated the 11th of December 2018, again to a number of people, including Mr Maffarage,
Yes.
and it states, you state just resending so everyone has it at hand.
Yes.
Okay, why did you feel it necessary to do that, that is resend that material?
Something happened around that date. I'll just have to refer to my statement. It was something in the media, I think.
Current affair program.
Yeah, if that would be, yeah.
Perhaps if we go to Exhibit 4166, Doc ID DSS.5093.0001.0312_R.
Yes, the current event story.
And what was the nature of the current affairs story? We can bring it up, in fact. That should be Doc ID RBD 9999.0001.0335.
Yeah, I'm pretty sure it was a reference to a QC in, QC in Victoria was going to challenge the scheme through the federal court.
So just for the record, that's Exhibit 4165. And if we go back to the previous email, call out the email at the bottom of the chain from yourself to Mr Maffarage, dated the 11th of December 2018. Says, Phil, a current affairs story on Robodebt. I'm extremely concerned that we are sitting on the legal advice. I think you should make sure that Brenton is aware of it. It will definitely end up in the federal court. Kristin.
Yes.
Why were you extremely concerned at that stage?
So it was just the build-up of all of these events over the last 2 years, and then sort of obviously getting the legal advice was hugely significant, and then that media story, that was how I felt.
Did you feel that there was inaction from those above you to act on the legal advice from Clayton Utes?
Yes, I did.
And you, were you seeking again to bring it to their attention so that they would act on it?
Yes, I was.
Thank you. And would this be right that you felt that there had been, sorry, I'll withdraw that. If we go to the next email on the chain.
It's lunchtime, but do you want to finish this point?
Yes, I do.
Mhm.
And there's an email forwarding your email from Mr. Maffarage to Miss Essex,
Yes.
11 December 2018.
Yes.
Comment, Allyson, further media on the Robodebt issue.
Yes.
Okay, and then we go to the next email on the chain. Miss Essex's response to Philip CCing yourself,
Yes.
dated 11th of December 2018. Says, Philip, Kristin, I'm aware of both the legal advice and its contents. I'm also aware of at least 2 external legal advices to the Ombudsman and DHS which come to a different and opposite conclusion. In formulating further advice, I'm having regard to the inconsistencies between the advices and the differences between the various requests for advice. I'm not sitting on the advice, which could have been clarified by further discussion with me. I do not think it will definitely end in the federal court. I have asked Beth to make an urgent appointment for us to discuss our approach. Ms. Lumley, had Miss Essex, to your understanding, done anything about acting on this advice between when it was brought to her attention in August 2018 and the date of this advice? Email, I should say.
I had no visibility that she had done anything with that advice.
There was nothing that you were aware of
No.
that she'd done. She refers to 2 external legal advices that come to a different and opposite conclusion. Do you see that?
Yes.
What did you understand the phrase 2 external legal advices to refer to?
I don't know what I thought at the time, but I've obviously read that since preparing for this, and I'm a little bit confused as to what she's referring to.
Would you agree with me that it's clearly seeking to refer to the existence of 2 independent legal advices?
Well, if it's too external, so I mean, she could class DHS advice as being external to the agency.
Right. Well, were you aware of 2, firstly, an external legal advice to the Ombudsman,
No, it wasn't.
an external legal advice to DHS?
To DHS, no, I was only aware of those 2 legal advices that had been done by the DHS lawyers.
Had either of them come to a different and opposite conclusion?
So I developed a summary table, which was included in my statement, where each of the advices I was aware of, and a summary of them, and whether I thought that they supported the program or not. And there is, some do, some don't.
Right. Commissioner, in order to finish this, perhaps...
Sorry?
I note your comment about the time, Commissioner. To finish this, it might take another 10 minutes before I move to the next topic.
Well, what's your preference?
I'm happy to go for another few minutes before lunch.
Okay.
Thank you, Commissioner. That can be taken down.
Where are we up to with the advice to Miss Essex? Did you have your meeting?
The one that she said I've asked Beth to schedule urgently. I don't have any recollection of that meeting. I'm not sure if if she just had the meeting with Mr. Muffarage, my director, or whether I was included, because I don't have a memory of it.
What's the next you hear of it all?
Beg your pardon?
What's the next you hear of the Clayton Utes advice and what's happening?
So that was, I again tried in February 2019 to get more traction on it when I recirculated it again. Allyson had left by that time.
Could the witness please be shown Exhibit 4168, DSS.5093.0001.0359? Is that the table you're referring to?
Yes, that's it.
And that's the summary table of the various advices that you identified in your research following the Clayton Utes advice, correct?
Correct.
And you referred to DHS advices. Do you agree with me that there's only two DHS advices identified there? That is a January 2015 one and an April 2015 one?
Yes, that's right.
Okay. And the April 2015 one, you've got the note in the outcome column, supports process.
Yes.
Did you understand that advice to specifically address the question of the lawfulness of averaging, or just the process generally?
The process generally,
Not averaging specifically?
no.
Okay, thank you. And then the document goes over 2 pages, but apart from that advice that I've just mentioned, can you identify any advices in that table that came to a different and opposite conclusion to the Clayton Utes advice? That is that.
2017 advice.
Oh, sorry, the January 2017 advice.
Yeah, that supports the process.
Yes, and that's an internal DSS advice?
Yes, no external.
Okay, and then the next page. And there's only 2 references there. One is the Clayton Utes advice,
Yes,
and then there's March 2017. It's just a reference to the DSS legal advice being provided to the Ombudsman,
yes,
which clearly isn't an external advice.
that's right.
Okay, thank you. Commissioner, I'm about to move on to new topics now.
Okay. We will adjourn till 2:10.
Thank you.
All rise. The Commission stands adjourned until 2:10 p.m. The Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Thank you, Commissioner. Could the witness please be shown document DSS.5006.001.0509_R should be Exhibit 88. Ms Lumley, can you see that document on the screen there?
Yes, I can.
And can you see that the subject of it is can you see that it's part of an email chain, the subject of which is legal advice sought on issue relating to recovery fee and PAYG online intervention?
Yes.
Can we go please to the third page of the document, last four digits, 0511. Ms Lumley, do you recognise that as an email from yourself to Ms Pulford, dated the 22nd of June 2016?
Yes.
I'm happy for you to read it yourself to familiarise yourself with it, but do you recognise it?
No, I probably need to read it.
Okay. Could you do that, please?
Yes, I've read that.
Thank you. Having now read it, do you recall that it is a request by you to Ms Pulford for legal advice in relation to the application of the recovery fee under the Social Security Act in the context of the PAYG online intervention?
Yes, it is.
And
Although it was referred to as a recovery fee, in fact, the legislation says a penalty, doesn't it?
Yes.
thank you, Commissioner. And PAYG online intervention would be a reference to the online compliance intervention?
That's right.
Okay. Which hadn't yet gone live by the time of this email.
Yeah, the measure had been implemented, but not the fully online process.
Yes, thank you. And towards the bottom of the page, the third last paragraph, that could be called out, the paragraph commencing the Ombudsman has raised.
Yes.
Do you remember the context that this relates to?
Yes.
Okay, and was that context that the Ombudsman was conducting an inquiry into the application of the recovery fee under the measure as it was being developed at that time?
That's right.
Okay. And can you assist the Commission at all as to the circumstances that led to that inquiry? That is, your knowledge of those circumstances?
No, so I think from something I saw, I don't think this wasn't part of all those other inquiries they did into the scheme. It was like a question that they had for the agency.
It happened before the 2017.
Yeah, I'm not sure No, I have no idea what the reason for it was.
Okay. But the question was whether DHS had sought any internal or external legal advice about a change of approach. See that?
That's correct.
And in consequence, or following that email, if we go to the page with the last 4 digits of the doc ID 0510, and call out your email, second last email on that page from yourself to Ms. Pulford, 27 June 2016. See there, you indicate to Ms. Pulford that you've obtained some additional information from the Department of Human Services.
Yep.
And that included attachment C, basically the default letter that will be issued to customers. Is that right?
Yes, that's right.
And is that a reference to the initial letter that would be used in the online compliance intervention process,
Yes, that's right.
where the customer would be informed of the existence of a potential discrepancy between the ATO PAYG data and the amounts reported by the recipient?
Yes.
Thank you. Okay. So if we go to the first page, an email from Ms. Ulrich to yourself dated the 1st of July 2016. See that?
Yes.
And Ms. Ulrich, was she a lawyer?
Yes, she was.
Okay. And the opening words of the advice is, "Hi Kristin, below is our advice and draft form." See that?
Yes.
And what follows is this, right, is the draft advice that she was putting to you in response to the questions posed in your instructions.
Yes.
Thank you. If we could call out, please, the third last paragraph. Oh, sorry, before we do, if we could call out the third paragraph. That refers to section 1122.8, capital B, subsection 1. See that?
Yes.
And that's the provision that deals with whether or not the, as you called it in your correspondence, recovery fee would be applicable, correct?
Yes.
And one of the circumstances identified in that section that is summarised there is that the recipient had knowingly or recklessly provided false or misleading information in relation to the person's income from personal exertion.
Yes.
And then the next words, when required under a provision of the Social Security law.
Yes.
And if we go to call out now the third last paragraph on the page. You can see in the middle of that paragraph, the advice describes the initial letter referred to an attachment C that had been identified in your earlier email as a notice under section 68(2), subparagraph B of the Social Security Administration Act.
Yes.
Thank you.
But it wasn't, was it? I mean, the whole point of this thing was not to be sending out notices under the Secretary's powers.
I don't know. I'm not familiar with that
Okay.
vision.
Perhaps if the witness could now be shown Exhibit 131, Doc ID DSS.5003.001.048_R. You accept that's an email from yourself to Ms Ulrich dated the 4th of July 2016,
Yes.
and your opening words were, "Hi Elizabeth, I have some concerns," as highlighted and read below.
Yes.
If we can go to the next page, last 4 digits, 0149. And unfortunately, the version that's on the screen doesn't have your concerns highlighted and read, so I'll ask you to just take it from me for the purpose of my next question, as to what part is highlighted and read. But if we could call out the second paragraph commencing under subsection 1228B sub 4. Are you prepared to accept from me, Ms Lumley, that the concerns in red that appear in the original version of this email are those words that appear between the dashes, that is the words, "Shouldn't the excuse relate to their underreporting of income picked up through the data matching, not their failure to respond to letter C?"
Yes.
And do you recall having a concern to that effect about the draft advice?
Yes.
And the point being that, is this right, you understood that the contravention of the social security law that would engage the recovery fee was not failure to appropriately respond to the initial letter under the OCI, it was rather the failure to accurately declare income in the first place, correct?
Correct. Yes.
Okay.
Had you thought much about that?
Which bit?
The notion that it must be an underreporting of income if there was a discrepancy with the ATO data matching?
I understood the whole premise of the measure was that that's what the data matching process identified. It identified a discrepancy that meant someone had underreported their income. That's what I understood at the time the measure.
Where'd you get that from, do you think?
DHS, that's what they told.
Who in particular?
I'd say Jason Ryman.
Because you might appreciate now it wouldn't work if, say, you hadn't been on benefit for the whole year or you hadn't worked for the whole year and the times didn't match.
I appreciate that now, yes.
But not then.
Not at the time.
Okay.
Commissioner, that's the evidence of the witness.
All right, can I just ask you this? It goes back to something I asked before. You were being given information from DHS about how this thing worked and you're getting advice on it.
Yes.
By mid-2016, people in DSS did understand how this thing was working. They weren't under any illusion that averaging was a dead issue. Would that be fair?
I think my view is that DSS had very limited understanding of how it was actually working until like January 2017 when the executive went over and met with DHS. That's my understanding.
How is that possible if you're getting advice on things like the imposition of a penalty fee to an average debt from DSS Legal?
It didn't refer to an average debt. I had no idea that there was any averaging involved when I was doing this piece of work.
Even though you knew there would be an application of the ATO data, presumably?
I didn't understand the detail of what was in the ATO data as to whether it had fortnightly data. I didn't know what the ATO holds.
All right, it's just a little hard to see how anybody clearly advises, unless it's understood how the debt's raised in the first place, how anybody clearly advises on a penalty.
Yeah, so that's, well, I didn't advise on the penalty. I sought legal
You sought
advice.
advice, I'm not suggesting you did.
Yeah.
And it does seem to give rise to the problem that averaging is a guess in the first place, and then somebody's being charged a penalty on the basis of that, which implies they've actually breached the Act on the strength of a guess.
In hindsight now, yes, that it does look like that.
Okay, thank you.
Nothing arising from that, Commissioner.
Right, Mr Glover?
No questions, thank you, Commissioner.
Okay, thanks for your time, Ms Lumley.
Thank you.
Excused.
Commissioner, I call Allyson Essex.
Ms Essex, will you take an oath or an affirmation?
Affirmation, please, Commissioner.
We'll get that administered, thanks.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks, take a seat, thanks, Ms Essex. Yes, Mr Scott.
Thank you, Commissioner. Ms Essex, would you please tell the Commission your full name?
My full name is Allyson Elizabeth Essex.
And you received a notice from the Commission requiring you to provide a statement dated the 28th of November 2022.
I did.
And you produced a statement in response to that notice dated the 2nd of December 2022.
I did.
Are the contents of that statement true and correct to the best of your knowledge and belief?
Yes, they are.
Thank you. You're presently a Senior Executive Service Officer at the Commonwealth Department of Health.
I am.
Previously, you worked at the Department of Social Services.
I did.
Is this right? Your substantive position from mid-July 2017 until 16 January 2019 was Branch Manager, Payment Conditionality, Design and Policy at that department.
Yes.
Between July to October 2018, is this right? You acted as the Group Manager within that department for Welfare and Housing Policy.
Yes.
And you hold a Master of Ethics and Legal Studies.
I do.
Thank you. Can the witness please be shown Exhibit 4142, Doc ID DSS.5093.0001.0314_R. Okay, can the email, second from the top, be called out, please? Ms Lumley's email to Mr Dowling on 9 July 2018. Do you see that email there, Ms Essex?
Yes, I do.
I appreciate you're not a party to this email. I'm not going to suggest you are involved in the email, that I'm just making clear, but I'm just want to ask you something about the first line in that email and the date of it. Do you see it's dated the 9th of July 2018?
Yes, I do.
And you see that Ms Lumley says to Mr Dowling, I understand in my absence, in my absence, Allyson requested that we formally seek advice from AGS about income averaging. Do you see that?
Yes, I do.
Now, in your statement, I think at paragraph 16, you might suggest that you'd requested legal advice to that effect later on the 23rd of July.
I see now that I would have had an earlier conversation than the one that I could locate in my emails from the 23rd of July.
Thank you. That's just what I wanted to clarify.
Yep.
If you could please call out the email at the top of the page. Responding to Ms Lumley's email, Mr Dowling responds, "Hi Kristin, I thought this one might get your attention. Yes, this was in the context of and the name of it, appeal is redacted. Allyson said there was no urgency for this, but happy to chat about it when you get in." See that? Having had the opportunity to prepare for today, you're aware, aren't you, of the appeal that's being referred to there?
Yes, I am.
Decision of the AAT in May 2018,
Yes.
which referred to an article by Professor Terry Carney earlier that year.
Yes.
Both the decision and Mr Carney's article said that averaging as it was being used in the Robodebt scheme was unlawful.
Yes.
You know that?
Yes.
Do you have a memory as to whether or not, prior to this date, Ms Lumley had raised with you on or about April 2018, sorry, I'll withdraw that. Do you have a memory of, or are you aware that Ms Lumley had sought approval to obtain external legal advice on or about April 2018?
I was on leave in April of 2018, so if she had sought approval then, depending on the date, I wouldn't have been in the role. I took some leave to attend the Commonwealth Games in April of 2018.
Okay. All right. Were you aware that Ms Lumley had, by the time you got back from leave, were you aware that Ms Lumley had significant concerns about the lawfulness of the Robodebt scheme?
No, I was not.
Okay. Do you accept that you had requested external legal advice because of the comments in that decision of the AAT and the Terry Carney article about the lawfulness of averaging?
Yes, I did.
Did you hold concerns about the lawfulness of averaging as it was being used in the Robodebt scheme?
Yes, I did.
What was the nature of those concerns?
I had two particular concerns. The first is that, as I understood the department's position at the time, DHS was required to have exhausted all other methods of obtaining the information that they sought before they used income averaging, or it was also referred to as income smoothing. And in that particular appeal case, it was clear that the authorised review officer had declined to use bank statements, and so I was concerned that they were applying the department's then, for want of a better word, agreed approach in a way that wasn't consistent with that. And I was aware of both pieces of advice. A piece of advice from the year before and a piece of advice from much earlier in the scheme, because I had been working in that area for some time, not payments integrity but social security policy, that it seemed to me I couldn't come up with a way that it could be lawful.
And just to be clear, lawful in the use of averaging at all, or lawful after making inquiries?
I had concerns that it might not be lawful at all. I had definite concerns that the way that I saw it being applied in the case that we're speaking about was not lawful.
So case-specific concerns, but more general concerns as well?
Yes.
Okay.
The Act doesn't say it's okay if it's a last resort, does it? It actually specifies it's income earned, received or derived. And the calculator talks about in the fortnight.
That is the case, Commissioner, and I have over the years had cause to revisit those sections of the Act.
That document can be taken down. You just said that you'd had regard to or knew of 2 previous advices.
Yes.
Was that the 2014 advice from Mr. Jordan, second counselled by Ms. Pulford?
Yes. I'm now aware that that's the date of that advice in preparing for this hearing.
But is that one of the advices that you were aware of?
That is one of the advices I was aware of.
And that advice said averaging is unlawful?
It did.
And then there was a subsequent advice by Ms. Pulford, and could this document please be shown to the witness? Exhibit 116, Doc ID DSS.8001.0001.5219_R. First 2 paragraphs could be called out from that email. Is this the second of the 2 advices that you mentioned just before?
Yes, it is.
Okay. And this advice purportedly gave the opinion that you agree with me that this advice gave the opinion that averaging was lawful as a last resort?
It did.
And is this right? Based on that AAT case that you're referring to, it appeared that averaging was not being applied as a last resort.
That's true.
And was that a concern to you at that time?
It was a concern, although it was not unusual for AAT decisions, particularly AAT 1 decisions, to express a different view of the lawfulness or otherwise of practices of the Department of Human Services.
Right. But to the extent that the department disagrees with those opinions, isn't the appropriate course for the department to appeal the decision of the AAT?
The practice at the time was to only appeal those cases which had a good prospect of success at the AAT.
And if the case decided that averaging was unlawful and a decision was made to not appeal, what was the practice then regarding continued application of averaging?
My understanding is that the practice would continue.
Are you aware of the terms of Section 8 of the Social Security Administration Act?
Not off the top of my head, Council, no.
Are you aware that section requires the Secretary in administering the Social Security law to have regard to the need to apply government policy in accordance with the law and with due regard to relevant decisions of the Administrative Appeals Tribunal?
Now that you read that section, I am familiar with that section.
And was there any view within the department about whether or not the practice to which we've just been describing was consistent with that provision?
There was certainly a strong view from the Secretary that it was.
Did she express that view to you?
I can't now recall if she expressed the view to me. I can recall her expressing that view in a meeting that I was part of in another role, and it was a well-known view within the department.
When was that other meeting?
It would have been before I took over the payments integrity function. I can't recall the date of the meeting.
What exactly are you describing as the well-known view?
There was a strong view which had been expressed to me by Mr. Williamson. As I said, I had heard the Secretary express that income averaging was lawful, and that the Commonwealth is on solid ground in using income averaging.
But that doesn't really account for AAT decisions to the contrary, which are never appealed.
It was, if I could take one step back, when the Secretary became the Secretary of the Department, she raised the level at which appeals could be approved to the Group Manager level, to the SES Band 2 level. Prior to that, appeals, Department of Human Services would provide what was called an AFAR, an advice regarding an appeal in relation to an AAT, one case that they thought was worthy of appeal. And then that decision would be made by the Director of the relevant policy section. After the Secretary came, it was shifted to the Band 2 level, and her reasoning at that time was that too many appeals were being agreed to by EL2s.
Okay, and the Secretary we're referring to is Catherine Campbell, isn't it?
It is.
Right.
See, as a matter of logic, if you wanted to appeal the things with good prospects, as you suggested was the mindset, if you thought you're on a sure thing with averaging, you would appeal it.
Yes.
But nobody ever did.
Not to my knowledge, Commissioner.
Right, thank you. And clearly the converse is true. If you thought you were in some trouble with averaging on this approach to things, you would not appeal it.
That's also true, Commissioner.
Can the witness please be shown Exhibit 4179, document ID DSS.5036.0001.008_R? Now, Ms Essex, you can see the heading of the document is Advice on Further Administrative Review.
Yes.
And an advice on further administrative review is an AFAR, as you've identified?
Yes.
Okay. The details of the case that's the subject of this advice are redacted for confidentiality reasons, but will you take it from me that this is the AFAR in relation to the particular matter that triggered your request for advice?
Yes, Council, and I recognise the Lex reference.
Thank you. Did you ever see this AFAR prior to today?
I was provided with advice about this AFAR firstly on the 1st of June in 2018. That is a date of some significance to me, which is why I remember it. And the view was that, so that was the first recollection I had of it. DHS legal proposed appeal on the basis of the treatment of income averaging, and this was the case in which they hadn't exhausted all their approaches, and the advice of DSS legal and the team was that the appeal didn't have good prospects.
Right. So when you say DHS proposed appeal, who in DHS?
My recollection is that it was the Deputy General Counsel, but I could be wrong in my recollection.
Who was the Deputy General Counsel?
I don't recall.
Okay, and you can see there in the subject or the heading, just below the heading, the words appeal deadline. Do you see that?
Yes.
12 June 2018 is the date for that deadline,
Yes.
being the date by which any appeal would have to be lodged.
Yes.
And I think you said that there was some significance to the 1st of June 2018.
Just to me.
Right, to you. And what happened on the 1st of June 2018?
Well, it might be something quite personal, is it?
It's my birthday, Council.
Oh, sorry. I thought you were referring to something in reference to this. I beg your pardon.
No. It's just my birthday, which is why I remember it.
Okay. All right. Well, were you involved at all in the decision to not appeal?
My first decision was that DHS should proceed with a protective appeal. In other words, they should lodge the appeal. subsequent to us getting some further advice about the dealing with the bank statements. And I can't now recall whether it came back to me when the protective appeal was withdrawn.
Okay, so was this protective appeal lodged after this AFAR?
It would have been lodged, a protective appeal would have had to have been lodged by the appeal deadline and then later withdrawn. I don't think the term protective appeal was a term used in the department. I don't know that it had a particular legal meaning.
Okay. Would you have read this document before causing a protective appeal to be lodged?
I would not have read the document. The team would have read the document and provided a summary to me of advice.
Summary of this document?
Not a written summary, but they would have summarised the general principles of the appeal.
Right. And by the department providing you that summary, people within DSS?
Yes.
Okay. Can the witness please be shown, or can we turn to the second page of the document? Call out paragraphs 10 and 11. In the summary provided to you, would words to the effect of those paragraphs have been provided to you?
I don't recall a discussion about that particular issue, so I cannot say.
Okay. Well, can you see that paragraph 10, it identifies the difficulty with this case is that DHS has been using a methodology that has and continues to be subject to criticism from a number of quarters.
Yes.
However, to appeal the decision would be to put that squarely into the public arena.
Yes.
To successfully defend the approach, the various arguments mounted against the process would need to be addressed. There is otherwise a risk that the whole approach of the OCI would be undermined. See that?
Yes.
And then those factors are identified as why in paragraph 11 an appeal is not necessarily recommended.
Yes.
Do you accept that those reasons identified in that paragraph 10 are not appropriate reasons to decide not to appeal?
Absolutely.
Right. Why is that?
Because the fact that you think a decision might be criticised is not a reason in and of itself to not get clarity. So my general practice would be to say to the team, where's the public interest lay? What's the test of what the benefit of the appeal is? So in this particular case, as I think you've rightly pointed out, it being criticised in the public arena is not a reason to not appeal.
And what about the risk that the whole approach of the OCI would be undermined?
It would not have been the first time that an appeal from an AAT decision, or indeed an appeal to the federal court, caused a significant change in policy, in my experience.
By that, do you mean an unsuccessful appeal?
Yep.
And so the risk that's being referred to there is the risk that there would be an unsuccessful appeal to the next tier of AAT and then the federal court, which would definitively establish that averaging was unlawful, correct?
Yes.
And as the paragraph identifies, thereby undermine the whole approach of the OCI.
Yes.
And is that an appropriate reason to not appeal?
No.
Are you aware of any other instances where no appeals were lodged to Tier 1 AAT decisions for that reason?
That it might undermine. Over the course of my career, I can't bring to mind a particular example. I'd certainly heard of those things, but I can't bring to mind a particular example to give to you.
Okay. Nevertheless, is this right? you caused a protective appeal to be lodged.
Yes,
That is an appeal being lodged pending further advice.
yes.
You obtained further advice
That's my recollection, yes, we obtained further advice.
from within DSS.
That would be the most likely course, yes.
And the advice was poor prospects of appeal.
No. My recollection is the further advice went to the ability of the Department of Human Services to instead use coercive notices to obtain bank statements. Or they may even have been non-coercive notices. I can't remember the section they were proposing to use, but use notices to the banks to get bank statements and then to calculate, recalculate the debt or otherwise based on additional information prior to using income averaging. That's my recollection of the advice.
What was the effect of the advice?
The effect of the advice is that the appeal wouldn't proceed and that the debt would go back to the department to be recalculated. In my understanding, according to the methodology that Mr. Carney had set out, in particular, the use of bank statements as proof of income.
In other words, in acceptance of the decision of the AAT.
Yes.
And so the protective appeal was withdrawn.
That's my understanding, yes.
Was that drawn to the attention of anyone above you in the department?
I can't recall. Normally there was a report, I can't now recall whether it was monthly because it's some time ago, but there was normally a report that went to the executive indicating appeals lodged, appeals withdrawn and so forth. Usually my recollection is that was prepared either by the legal area or by the Department of Human Services legal area.
Are you aware of the Commonwealth's model litigant obligations, Ms Essex?
Broadly, Council, yes.
Are you aware that an aspect of those obligations requires it's an aspect of the Commonwealth's model litigant obligation that the Commonwealth must pay legitimate claims without litigation where it is clear that liability is at least as much as the amount to be paid?
I don't specifically recall that, but I accept that that is part of the obligations.
Is it consistent with what you understood the Commonwealth's model litigant obligations to be at the time of the decision-making regarding this matter that you've been discussing?
In hindsight, no.
Hindsight, sorry?
In hindsight, no.
You weren't, that's not consistent with what you understood? No. Okay. Because would you agree that the effect of the course which the department took in response to this matter was effectively to accept the position identified in the AAT Tier 1 decision that averaging as it was being used in the Robodebt scheme was unlawful?
Yes, I agree.
And did the department continue to average?
So the Department of Social Services did not undertake any averaging to the best of my knowledge. The Department of Human Services was a separate Department of State, and I have no knowledge as to what they did or didn't continue to do.
I apologise. I was imprecise. I should have been more precise. So you don't know whether averaging was after the protective appeal was withdrawn. And what date was the protective appeal withdrawn?
I don't now recall. It's not something that was in my emails.
Right. But is it your evidence that you have no knowledge after the withdrawal of that protective appeal whether the Department of Human Services continued to use averaging in the Robodebt scheme that had been the subject of criticism by the AAT in this decision?
I have no personal knowledge of that, no.
Did you take steps to advise DHS that averaging should cease immediately given the acceptance by your department of the AAT Tier 1 decision to the effect that it is unlawful?
No, I didn't.
Why didn't you?
That would not normally have been my role. That would normally have been done at the officer level, and there was there were significant discussions at that time around a range of other matters with DHS. So I don't now recall having that specific conversation.
Would it be within your role to brief your superiors about the need to inform the secretary of your department that the department had accepted at that time that averaging as it was being used in Robodebt was unlawful?
It was within my role to raise significant issues with my superiors, yes.
This was a significant issue?
This was this was an issue about which there was some discussion. It was not, at the time, considered particularly significant in the department.
Ms Essex, the effect of the conclusion of the AAT, which your department accepted as correct, was that the Commonwealth was taking from social security recipients on a massive scale money from them which the Commonwealth was not entitled to. Do you accept that?
I accept that that's the effect. I am clear that that was not how it was seen within the department at the time.
Or was it seen by you in that way?
Yes.
So why did you not take immediate steps to raise the matter with your superiors?
I don't have the benefit of having access to my diary from the time. It would have been my normal practice to speak to my manager, my direct manager, about those sorts of issues in regular catch-ups, but I don't have access to my diary at the moment, so I can't tell you what I did or didn't discuss at that time.
Well, surely if you'd raised it, it would be documented, wouldn't it?
Not always.
Something of this nature?
Not always.
Why not?
A lot of those discussions were verbal.
Wouldn't you surely cause a brief to the secretary be drawn up?
In order to brief the secretary, I would have to get agreement on the wording with, depending on which role I was in, the deputy secretary or the group manager and the deputy secretary. In my experience, it was best to clarify the wording of that before you sent a briefing to the secretary. Not all briefings to the secretary made it to the secretary.
Well, you accept there was no draft?
No. The process that I'm taking you through is the process of developing that kind of a draft.
And you acted as group manager from July 2018?
Yes, I did.
So you would have, the next level up from you from that point on would have been to the Deputy Secretary, Mr Williamson?
Yes, it was.
Did you make any attempt to raise it with him that there was an urgent need to brief the Secretary?
No, I sought the legal advice that we've previously discussed to see if Mr Carney's reasoning was likely to be sustained, and I discussed it with him after that advice had been received.
We'll come to that.
Yep.
I'm asking about this.
I have no recollection of escalating it at that point, no.
Okay, thank you.
Can I just ask you this? You mentioned that if it were raised with DHS, it would be at officer level. What's officer level?
So officer level would be APS or EL staff, so Miss Lumley or Mr Maffarage or Mr Dowling would typically have raised those sorts of things.
All right, thank you.
That can be taken down. Can the witness please be shown Exhibit 1220, Doc ID CTH.3004.0010.5247. Do you recognise that document, Ms Essex?
Yes, I do.
That's the Ombudsman's April 2017 report into the online.
Yes.
Thank you. And are you aware that there is a letter from Mr Pratt, the former Secretary of the Department, attached to this report?
Yes, I am aware that there is.
Okay, and are you aware of the general contents of that letter?
Not off the top of my head, but I was provided with the paper so I can have a look.
Okay, thank you. Can we have on the screen the 52nd page of that document, which should have as the last four digits .5301? Okay. Now, I'll just ask you to, not allowed, read to yourself. Firstly, see who it's from. Top right-hand corner, Mr Pratt,
Yes.
former Secretary. To Mr Glenn, then Acting Commonwealth Ombudsman. And you can see from the, I'll just ask you to read to yourself, but not allowed, the first paragraph.
Yes.
Read that. And if we go to the next page, do you see that it's purportedly signed by Mr Pratt on the 4th of April 2017?
Yes.
Except that's Mr Pratt's letter to the Ombudsman in relation to the 2017 investigation.
Yes, I do.
Thank you. Can we go to the previous page? Can we call out the third last paragraph? Next paragraph. Do you see that paragraph there, Ms Essex?
Yes, I do.
And do you see the words, the department is satisfied the system is operating in line with legislative requirements and there have been no changes to the way in which DHS assesses pay-as-you-go employment income?
Yes.
To accept that, by July 2018, so far as you're concerned, you couldn't be satisfied of that, could you?
No, I couldn't.
That can be taken down. Can the witness please be shown Exhibit 4156, Doc ID DSS.5099.0001.0001_R. we call out, please, the last email on that page. To see that's an email to a number of people, including yourself, on the 21st of August 2018,
Yes, I recall that email.
9:13 a.m.
Yes.
Refers to attached correspondence from the Ombudsman's office
Yes.
in relation to an entry meeting concerning the employment income confirmation stage 2 report implementing investigation.
Yes.
All right. And could the witness please be shown Exhibit 4157, Doc ID DSS.5099.0001.0003_R. Do you recognise that letter, Miss Essex? Perhaps if we, you can see that it's dated the 20th of August 2018.
Yes, I can see that.
And if we call out the first paragraph in the subject line, just read that to yourself and not aloud.
Yes.
And do you accept that that identifies that the subject of this letter from the Ombudsman is the investigation referred to in that email that we just discussed?
Yes.
Thank you. Now, could go to the third page, please. We call out the section headed Importance of Publicly Available Guidelines and the 3 paragraphs underneath it. Sorry, and the paragraph beneath that as well, 3 paragraphs. Now, do you recall reading these words in this letter?
Yes, I do.
Do you recall reviewing this letter on or about the time of the email we discussed before?
No, it would have been sometime after that. So the entry meeting, I think, was the 4th of August, which Ms Armstrong attended. I didn't attend to the entry meeting. And the normal process would have been that she dealt with this as the acting branch manager. And then I would have read it maybe a couple of weeks after the date of this, when the response was being sent back.
Right. Okay. Do you accept that a premise of the letter is identified in the first paragraph in that section called out, which is that the Ombudsman considers it may be open to the government to argue that the EIC process of averaging income is legal, but the legality of the system is not certain?
Yes.
And do you accept that in those circumstances, particularly after Mr Pratt's letter on the 4th of April 2017, that if the department was no longer in a state of satisfaction that the practice of averaging was legal, that it was imperative that the response confirm that it was no longer so satisfied?
That was a view I put at the time, but it was not a view that was held by others.
Put to who?
Mr Williamson.
How did you put that view to him?
When we discussed, and you may get to this later, he sent an email around the 26th of August that said, can we discuss this in our catch-up? In the course of that catch-up, I told him about the Clayton Utz advice and said, we've got an advice that says it's not legal. His response to me was, it's legal, it's really clear that it's legal. By all means, if we have a robust advice, let's evaluate the situation, but it's legal.
26th of August.
That's when he sent me the email. My catch-up with him would have been in the days following that.
So we go to the previous email. the email we had on the screen earlier. So that's Exhibit 4156, doc IDs, DSS.5099.0001.0001_R. Call out the email at the top of the page. Is that the email from Mr. Williamson you're referring to?
That's the email I'm referring to.
Right. And just to put this in the sequence of the chronology, by that stage, the Clayton Utes advice had been provided.
Yes,
It was in draft,
yes.
but it was clear that the substance of it was not going to change.
I don't accept that it was clear the substance was not going to change.
Okay, well, let's go to that. This document can be taken down. Exhibit 4147, doc ID DSS.5044.0001.0176_R. Call out the email at the bottom of the page. Do you accept that's an email from Miss Fredericks?
Yes,
Melanie Metz and Anne Pulford, dated the 14th of August 2018.
yes,
And you accept that in that email, Miss Fredericks refers to a discussion she's had with one of the lawyers who is the author of the advice,
yes,
who has said they might be able to rework the advice subtly if this causes catastrophic issues for us, but that there is not a lot of room for them to do so.
yes,
All right. Do you accept that the reference to the Clayton Utes advice in this email is the draft Clayton Utes advice that we've been discussing?
yes,
And do you maintain, in light of that email, sorry, I'll withdraw that. Can we please call up the next email in the chain? It's an email from Ms. Pulford to Ms. Lumley, dated the 14th of August 2018. Do you see that?
yes,
And you see the last line of that email before the word regards? Let me know how you'd like to progress this, given the conclusion and limited room to adjust the outcome.
yes,
And if we go to the first email in the chain, so last, at the top of the page, this is an email from Ms. Lumley to yourself, dated the 15th of August 2018. Do you see that?
yes,
It says, "Hello, Allyson. Phil has asked me to forward on a copy of the external legal advice we've just received on income smoothing. Please note Anne Pulford's comments below."
yes,
And that's clearly a reference to what Ms. Pulford said earlier about the limited room to adjust the outcome.
yes,
Now, that's clearly indicating that the substance of the advice was unlikely to change, isn't it?
In my experience of dealing with both Miss Pulford, who had previously worked for me and who I had worked with quite closely as a lawyer within the department over a range of different issues, and my previous experience with draft advice, it meant that she thought there was little room to move, but that didn't mean we shouldn't explore whether that was the case. There have been other circumstances where draft advice changed relatively substantially because additional facts were brought to bear or an additional piece of information was provided. And so in response to that, I set up a meeting with Ms Lumley and Mr Mafarage to talk through their discussions with the legal area.
Well, it was obvious, I suggest, from the comments from the author, one of the authors of the advice referred to in Ms Fredericks' email, in specifically pointing out they might be able to rework the advice subtly if this causes catastrophic issues, but that there is not a lot of room for them to do so, that previous experience you're referring to would not apply here.
I have seen similar wording in the past where there was substantial movement in the advice. I didn't know at that point whether what the room within the advice might be. I accept your assertion that on the face of it, those words seem that there's not much flexibility, but in my experience, it was worthy of testing that further.
All right, well, by this...
Wrong. It suggested it got to the same point, but by a different mechanism to the mechanism that Mr Carney used. And that was one of the things of concern to me. Not the only thing, but one of the things of concern to me is that if external advice said that Mr Carney's reasoning did not hold, then would Mr Carney's decision still hold on appeal? That was my first question. The second question was, if Mr Carney's reasoning didn't hold, would it be the case that this reasoning wouldn't hold? Because in order to brief the Minister or indeed the Secretary, I needed to be able to cover off the obvious questions in the advice that I had.
They were just arguing... Sorry.
Apologies.
You go, Mr Glover.
Interrupt. I just wanted to mention my learned friend, Mr Scott, in two questions there referred to the name of the decision. I just raise it for your
You
consideration.
want it out of the transcript?
Yes.
Yep, all right. So the name of the decision is not to appear in any published transcript. Look, the area of argument was just about the Briginshaw standard, wasn't it?
Sorry, Commissioner, could you repeat the question for me?
The area of difference between Clayton Utes and Mr Carney was just Briginshaw standard, wasn't it? Or was there more?
I would have to go back and look at the advice in some detail to come back to explain to you what my particular concerns were. And I stress that I don't hold a law degree, and so I knew that I needed further advice.
All right, well, just to be clear, Ms Essex, if the witness could be shown Exhibit 135, Doc ID DSS.5006.0001.4242_R. And if page 6 of the document could please be brought up on the screen. And section 5.1 to 5.4 brought up, please. Ms Essex, can you read those sections to yourself, not aloud, please?
Yes.
It's plain from those passages isn't it, Miss Essex, that the area of disagreement related to how the ultimate conclusion was arrived at by Clayton Utes as compared to Mr Carney, as opposed to any substantive doubt about the ultimate conclusion?
So the issue for me was that the mechanisms for getting to the decision were different, and I needed to understand what that was. I accept your contention that the end result was the same, but in my experience, the method that you use to get to the end result can sometimes be important both in matters of policy and in matters of appeal. It also goes to any solution that government was looking at to address this issue. We would need to understand that well. The second point that I'd make is that the advice refers to youth allowance and New Start recipients, and while that was the bulk of these cases, they were not the only ones. And so it also raised a question in my mind as to whether the same would apply in relation to other payments.
Sure, but regardless of how Clayton Utes differed in how they arrived at the conclusion, this is clear advice that, at least in respect of those two categories of payments, averaging as was being used on a mass scale was unlawful, wasn't it?
This is clear draft advice that that is the case, and I wanted to explore that advice further.
How long would that take, Miss Essex?
That could take some time, and it was not unusual for that process to take a number of months, including getting various pieces of advice. Because the end result is what, or the thing in my mind at the time was, what is the authority or process that's needed to end the practice?
What does that mean?
So this, and I'll take you through my understanding at the time, and please stop me if you wish to. In order for government decisions to have to be made, there needs to be an authority for those, generally a cabinet authority. Sometimes it's a letter to the Prime Minister, sometimes it's exchange of letters between ministers depending on the process. And this was a budget measure, is my understanding, where the Department of Human Services had put up a savings measure. Because it was a compliance measure, the Department of Human Services got to keep the save, and the impact if they did not continue to meet their commitments that they had made in their new policy proposal and in their costing is that there would be estimates, variations over the forward estimates as the payments that needed to be paid out would be increased. That's kind of how the process worked. So in order to stop something that government implemented, could the minister do that on his or her own? Would it require a cabinet process? Did it require a letter to the Prime Minister? What would be the authority in relation to that? And in order to support that process, what was the documentation that needed to be in place to do that? And that's what was in my mind at the time.
All questions which you should have explored with absolute alacrity, given the significance of this advice, correct?
Given that at the same time there was a proposal before government to end the scheme, I did not see it as requiring the same level of alacrity.
Well, Miss Essex, in those circumstances, that's a very good reason to bring this advice to the attention of government if there's a proposal to end the scheme then under consideration, because it's relevant to that decision, isn't it?
Not in the context in which that decision was being proposed, which was in the estimates variation.
What was the proposal to end the scheme?
So there was an estimates variation process. It started as a cabinet submission, ended up as an oral briefing to cabinet by Minister Fletcher and Minister Keenan, but it was originally a cabinet submission that was led by the Department of Human Services. And one of the recommendations that was proposed in the original drafts was that the scheme should cease. The Department of Human Services wanted additional funding to extend the number of cases but we had briefed that the scheme should cease.
And in those circumstances where there is advice that the scheme is unlawful, that's a very relevant consideration whether or not to end the scheme, I suggest.
The timing was such that those two things were happening in parallel, that I was seeking a better understanding of the draft advice and that cabinet process was appearing in parallel. I can see why that draws criticism from you, and I'm not resiling from that. But that was not my understanding at the time.
Do you accept that you did not act with alacrity at all?
I maintain that I acted as quickly as I could within the circumstances and my level of understanding at the time. That may not meet the Commissioner's test or your test for alacrity, but I believe that I progressed it as quickly as I could.
Did you do anything before you left the department in January 2019 about acting on this advice?
Yes.
What did you do?
So I particularly raised it with Mr. Philp. Before I knew that I was leaving the department, I raised it with Mr. Philp, and I asked for his opinion because I knew that he was legally qualified, and I discussed it with him. He was quite clear that advice is advice. The view that he expressed to me was that advice does not necessarily have to be followed. I said that I would value him looking at it and reviewing it and thinking about or providing some advice on how he thought we should progress it. I acted, so the minister's briefings closed, I think, from memory around the 19th of December because Minister Fletcher was going on leave. We had departmental close down around the 21st of December. Nothing really gets progressed around that time. I had already had a conversation with Miss Lumley and Mr. Maffarage where I said I was very comfortable with the advice being finalised, and they might want to consider whether they wanted input from Mr. Philp in the process of doing that, but I was very comfortable for it to be finalised. And in fact, I would have been comfortable for it to be finalised a couple of weeks before that, sometime before that. And then when Mr. Philp returned from leave, I reminded him that I had provided him with the hard copies of the documents.
All right. I'm going to take you through some documents about this, Ms. Essex. Are you aware that Minister Fletcher was sworn in as a new minister at the end of August 2018?
I was.
Did you take any steps to cause the nature of this advice to be included in his incoming ministerial brief?
The incoming ministerial brief was coordinated by Mr. Bennett, who was at that time acting Deputy Secretary, and he was very clear about what would and wouldn't be included. And only the Department of Human Services wording around the online compliance initiative was to be included.
Did you take any steps to cause the nature of this advice to be included in that brief? That's my question.
I spoke in the course of indicating what could be provided in the brief. I spoke to the coordinating area about the fact that there were concerns about the legality of the scheme, and would they like some words on that?
There was advice that it was unlawful, wasn't it? And you didn't raise it?
There was a draft advice that it was unlawful that we were still seeking to finalise.
When were those discussions?
So if the minister, could you just remind me again the date that the minister was sworn in?
End of August 2018.
So my recollection that would have been around the time that Mr Morrison became Prime Minister. And so there would have been a very short window for preparing an incoming minister brief. So it was probably prepared within 5 days. We would not necessarily have had notice, except for the change in Prime Minister. We wouldn't have had notice that there was a particular cabinet reshuffle underway. So I don't recall the exact timing, but it would have been around then.
This was a very significant matter, I suggest, Ms Essex.
In the context of the time, it was not perceived as a significant matter.
It was to the effect that, at least in respect of 2 payments, the subject of the Robodebt scheme, a fundamental aspect of that scheme was unlawful, wasn't it?
That is certainly what the draft advice said, yes.
Major government policy that had been the subject of significant media criticism.
That was not an unusual situation to be in relation to social security policy.
A scheme that had operated, at least in the form of the online compliance intervention and then the EIC process, since the end of September 2017.
16.
Sorry, 16, I beg your pardon, Commissioner. Correct?
Yes.
And according to this advice, in respect of those 2 categories of payments dealt with in this advice, that had been unlawful.
It was also the case that there was a legal advice from 2014 that said it was unlawful. And government had made a decision to continue, a point that was reiterated to me by Mr Williamson.
Is this that discussion on the 26th of or
No, that would have been in a different discussion when he arrived in the department, and we had there would have been an incoming Deputy Secretary's briefing, there would have been a discussion around what was happening within the space. The normal part of that, because all media clips go to all SES each morning, it would have been clear to him, and he had come from the Social Policy Division job in the Department of Prime Minister and Cabinet, so he would have been very aware of this. He was certainly aware of the inability of the Department of Human Services to hit their targets. And prior to that, he'd worked at the Department of Human Services with Catherine Campbell, and he had a more detailed knowledge of the scheme than I did.
And he said he had reiterated to you when he came into the department the fact that there had been a 2014 legal advice that said this scheme was unlawful.
Words to the effect that people have said it's unlawful before, it's been found to be lawful.
By whom?
My recollection of that conversation with him was he was referring to things he knew either from the Department of Human Services or Prime Minister and Cabinet. At the later discussion I had with him, where we spoke about the Ombudsman's request around the guide, and I mentioned the Clayton Utz advice, he said Ombudsman and the Department of Human Services.
But this was an external legal advice. Correct?
It was, but as I said, the view that Mr Philp put to me, that advice is simply advice and we determine what we do with that advice, was a common view in the department.
Independent legal advice.
Yes.
Disregard the advice.
It was not unknown.
Who's Mr Philp?
Mr Philp became the group manager. He had So it would have been around October when I reverted to my substantive role. I would have a catch-up with him about once a month, but I provided briefing to him, as I think I indicated in my statement, around the 15th of October as he was coming into the group. Quite a busy group, quite a lot of different things going on at the time. The estimates variation was one of those things that we were discussing at the time. So Mr. Philp was the group manager. He wanted to go, he was taking a period of leave over December and the first week of January. He asked if I could act for him, and then I was subsequently offered a job by the Department of Health, which I advised him of, and we negotiated me shortening my leave so that I could act for him over the Christmas New Year period.
I see. And you say you had this conversation with him in October 2018?
I had an incoming conversation with him, yes. And then I had a subsequent conversation with him, as I indicated in my statement in December.
About this?
About the Clayton Utz advice, yes, I gave him the folder that Miss Lumley had prepared for me.
I see. Could the witness please be shown Exhibit 4159, Doc ID DSS.5093.0001.0313_R. Sorry, that can be taken down. Do you recall there being a discussion with Miss Lumley about the advice on about the 21st of August 2018?
I didn't until I had the opportunity of preparing for this hearing where it was... No, I want to withdraw that. I was aware of the 21st of August because I mentioned in my statement, and there was an invitation. In the emails I looked at, there was an invitation for that meeting. Miss Lumley, Mr Maffarage, Miss Armstrong and Mr Kemp were present at that meeting.
Do you accept that meeting occurred?
Yes.
Do you accept that you said about the advice, words to this effect, that you'll raise it with Nathan when the time is right?
Yes, and I'm happy to clarify what I meant by that.
What did you mean?
I meant after I'd read the advice. I meant after, at probably my next catch-up. It's a phrase I used quite commonly to mean after I had enough facts to have a sensible conversation with my manager. As it happened, I had that conversation within the week. It was not my intention to delay it any further than necessary.
May the witness please be shown I think it's Exhibit 4161. doc ID DSS.5003.001.0768. Do you see that email chain, Miss Essex?
Yes, I do.
Okay. And you recall the correspondence from the Ombudsman we discussed earlier in
Yes.
yes. And you can see, that this email purports to attach a response to that correspondence
Yes.
sent on the 7th of April 2018.
7th of September 2018 is the date I have in front of me, Mr. Scott.
Yeah, sorry, 7th of September. If we can call out, please, doc ID DSS.5003.001.0770, Exhibit 4162. Now, Miss Essex, I think you said earlier that some weeks after the letter from the Ombudsman, you reviewed it.
Yes.
And did you review this letter in response to the... You're not aware of the contents of it?
I am now aware of the contents. I wasn't at the time. That was dealt with by the branch manager, as was the normal practice.
I see.
And Mr. Kemp, to the best of my recollection, didn't discuss it with me.
Right. Did you take any steps to instruct Mr. Kemp, who was reporting to you as acting branch manager at the time, correct?
Yes,
You were acting group manager at the time?
I was.
Did you take any steps to instruct him to advise, include in this letter, advice to the Ombudsman about the Clayton Utes advice?
I don't think he spoke to me about this letter before it was sent.
Well, you're aware of the letter from the Ombudsman,
Yes.
a matter of weeks after the letter from the Ombudsman was sent.
Yes.
Was that before the 7th of September 2018?
I can't now say the date on which it was the case, but as I said, to the best of my recollection, Mr. Kemp did not discuss this particular letter with me, and that would be the normal course of events, that would have just been dealt with at the branch manager level. And I note on the letter that Mr. Maffarage is the contact for the letter, so it would have been prepared by Mr. Maffarage. I wouldn't normally have expected to see it. I take your point that it would have been desirable if I had, and I take your point that I should have been more mindful of the fact that that response was due to go.
Well, do you think that once you did read the letter from the Ombudsman, you should have been mindful of the fact that by the time you read the letter from the Ombudsman, you had Clayton Utes advice that said the scheme was unlawful?
I had draft legal advice that I was seeking to clarify. In the normal course of events, we may have gone back to the Ombudsman around that. But it didn't present itself to me as something that I should have done at the time. And I recognise that you are critical of that.
Could the witness please be shown Exhibit 4167, Doc ID DSS.5093.0001.0316_R. Sorry, it should be Exhibit 4166, Doc ID DSS.5093.0001.0312_R.
Not having a lot of luck there. Do you want to send someone to inquire?
Could call out the email at the bottom of the chain. It's an email from Ms Lumley to Mr Farage dated the 11th of December 2018. Do you see that?
Familiar with the email?
Do you see that in reference to a current affairs story on Robodebt, Ms Lumley identifies that she was extremely concerned that we are sitting on the legal advice? Do you see that?
Yes.
Which is obviously in reference to the Clayton Utes advice.
Yes.
And then the comment, it will definitely end up in the federal court. Do you see that?
Yes.
Go to the next email in the chain. Email from Mr Farage to yourself forwarding Ms Lumley's email,
Yes.
11th of December 2018.
Yep.
Go to the next email in the chain. Call that out. Says, I'm aware of both the legal advice and its contents. I'm also aware of at least 2 external legal advices to the Ombudsman and DHS, which come to a different and opposite conclusion. What were the 2 external advices to which you were referring?
The 2 that Mr Williamson had mentioned to me in the past, which I now think may not have been external advices, but that was my belief at the time.
Did you cite them?
No.
The next.
If I had seen them, I would have said I had read them. I said I am aware of them, which in my mind means I hadn't seen them.
The next sentence says, in formulating further advice, I'm having regard to the inconsistencies between the advices.
Yep.
How could you have regard to the inconsistencies between advices which you hadn't seen?
The effect of the advices. I could have been more precise in my language and said the effect of the advices. If I was to write a very full email, I would have said the words to the effect of the advices, the common view in the department, and the different questions that were asked. I sent that off fairly quickly because I wanted to talk to them fairly quickly, and I also was aware that Mr Farage had raised with me concerns about Ms Lumley's concerns, and that she was quite, his words to me were that she was angry he had forwarded her email on to me, and I didn't want her to think I wasn't taking it seriously.
Ms Essex, I suggest to you that on the 11th of December 2018, months after you received the Clayton Utes advice, you had done nothing to do anything about the advice.
I don't accept that.
What did you do?
So I had read through the advices. I had worked through in my own mind, to the extent that I was able, the logic across the various things. I had turned my mind to which questions might need to be answered. I'd had a conversation with Mr Kemp. I had indicated that a ministerial briefing should be prepared. When I came back to the job, to my substantive job, it became clear that that hadn't been prepared, so I started to turn my mind to what that would look like. I had regard to the fact that I could not brief, even as a group manager, I could not brief the minister without it going through the deputy secretary, and in this case the secretary. I had turned my mind to the level of force that the argument would need to have for that briefing to go forward. I had turned my mind, as I'd indicated earlier, to questions of authority, and I had turned my mind to the best way to do that to protect my staff in that process. I accept that you don't think that I did that as quickly as I could have.
Well, apart from having a conversation with Mr Kemp indicating that a ministerial brief should be prepared, everything that you've described about what you'd done was simply turning your mind to various things.
As I said, I had mapped out what I thought the issues were. I had had more than one conversation, but as I said, I don't have access to my diary from the time, so I can't tell you the dates and times of that, and I wouldn't give evidence of things that I wasn't sure had happened. But it would have been my normal practice to have regular conversations with this. I note that both Miss Armstrong and Mr Kemp made reference to this in their handover from Miss Armstrong to Mr Kemp, and then the handover to me. It wasn't the case that I was ignoring the issue. There were a range of other things happening at the time, that's true. There were a range of other considerations at the time, but I did turn back to that a number of times. I read through that folder several times, not just once. And perhaps I could have done that more quickly, but I didn't.
I suggest to you that what really happened was you continually made excuses to deal with the advice so that you didn't have to deal with it before you left the department in January 2019.
That is not the case. In fact, until the 13th of December, I did not have a letter of offer to leave the department.
Well, until up to this point, you were continually making excuses so as to not have to deal with the advice.
I don't accept that.
That's the evidence of the witness, Commissioner.
Mr Glover?
Might I just have a moment, Commissioner, to mention something to my learned friend, Mr Scott?
Certainly.
Thank you. Oh, thank you for that, Commissioner. Just given that some of this evidence has moved forward in time somewhat, and there may be some further investigations that need to be made in relation to Miss Essex's diary, for example, the Commonwealth would defer any questions at this stage.
All right, thank you. So what about excusing Ms Essex where we are or we aren't, from your perspective at any rate?
From the Commonwealth's perspective, Miss Essex can be excused if a further summons needs to issue. That can be done.
Okay, you happy with that?
Might I just briefly confer, Commissioner? Given the prospect of further investigations, perhaps it's not appropriate to excuse the witness, Commissioner.
Right. Look, I won't excuse you, Miss Essex. It doesn't mean you're necessarily coming back, but it leaves open the possibility without serving you with another notice if necessary. All right. Thank you, but you can certainly leave for the afternoon. As may you, I think.
It is, Commissioner. Mr Gregory will be replacing me.
Oh, Commissioner, just while that is happening, that also concludes my involvement in today's proceedings, so may I be excused?
Yes, we'll try not to look at you with envy. Thank you. We're getting there, Mr Carter. Mr Gregory?
Yes, Commissioner, I appear for the last witness of the afternoon, which is Mr Carter.
All right. Mr Carter, will you take an oath or an affirmation?
An oath, please.
Fine, we'll get that administered.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Take a seat, thanks, Mr Carter.
Thank you.
Yes, Mr Gregory.
Yes, thank you, Commissioner. I should indicate I appear with Mr Freeburn of Council as well.
Yes.
Mr Carter, can you tell the Commission your full name, please,
James Edwin Carter.
and your current position?
I'm currently acting Commonwealth Solicitor for Public Prosecutions in the Office of the Commonwealth Director of Public Prosecutions.
You have held various positions in the Office of the Commonwealth Director of Public Prosecutions for many years.
Yes, that's so.
And over those many years, we won't specify them, but you've had close involvement in and supervision of cases relating to welfare fraud.
Yes, that's the case.
And you've had those roles at a national level.
Yes.
Mr Carter, you were served with a notice to give a statement, NTG-0112, dated 29 November 2022, and you have produced two statements in response. The first dated 21 December 2022 and the second dated 23 January 2023.
Yes.
The contents of your statement and your supplementary statement true and correct to the best of your knowledge and belief?
Yes.
Thank you. Mr Carter, could you very briefly, appreciating that you have set out these topics in some detail in your statement, provide us with an overview of the role of the DPP?
The Commonwealth Director of Public Prosecutions is responsible for the prosecution federally of offences against federal law and in some cases state and territory provisions, but our role is as a federal prosecuting agency, and we prosecute based on briefs of evidence that are referred to us by referring agencies. It may be the police, or they may be departments or agencies with an investigative capability, and those briefs are assessed by the CDPP in accordance with the prosecution policy of the Commonwealth. And prosecutions may then commence, and the CDPP has carriage of those in the courts across Australia.
Of course, it's an independent statutory body.
That's correct.
And the prosecution policy to which you referred involves a two-stage consideration.
That's correct.
The first stage involves an assessment of the evidence
That's correct.
and whether there are reasonable prospects of success.
That's correct.
The second involves a question of whether the prosecution, if it were to commence, is in the public interest.
That's correct.
And the second stage assessment is only reached if the first is satisfied.
That's correct.
Yes.
I don't know that Mr Carter's exhibits have already gone in.
No, they haven't, quite right, Commissioner. There
Got them
is...
starting at 3989, is that right?
It is. There is a topic of unresolved legal professional privilege claims. Can I tender them this way? Exhibits 3989 to 4064 and 4126 to 4130 as they appear on the draft.
Sorry, 3989
4064
and then
4126 to 4130.
0. Right, they're admitted with the respective numberings in the schedule. And so is there a little body in the middle?
There is. And that's the subject of the unresolved question. I'm not.
Does it need resolving?
Not immediately.
Okay.
It can be deferred, and I defer the tender of those exhibits. Mr Carter, you referred to the referral of various investigative agencies. One of those historically has been Centrelink, or the Department of Human Services, now Services Australia.
That's correct.
The CDPP itself doesn't have any role in conducting an investigation into matters which are referred to it for prosecution.
That's correct.
Although, in respect of Centrelink or DHS, historically it has a close relationship in terms of advising and training about the nature and extent of the investigations which ought to be conducted in order to lead to a body of evidence which might pass the first test of the prosecution.
That's correct.
Yes. And in that context, you personally have had a good deal of interaction with Centrelink and DHS over a number of years, including at annual conferences where both CDPP officers and officers of DHS attend.
Yes, we regularly had an annual conference. That was the normal arrangement. And that was in addition to generally quarterly liaison meetings at a national level. And there were also liaison meetings at a regional level with the representatives of Centrelink DHS in that region.
One of the positions of the CDPP in respect of the prosecution of cases of welfare fraud has long been that it would not prosecute cases on the basis of averaged earnings information.
Income cases, that's correct, yes.
Yes. Can you explain why?
Because for the purposes of a prosecution, it's necessary to consider the evidence that is required in order to establish the elements of the offence being considered. And in relation to this area, that relates to the obtaining of a benefit. And it's necessary to show that that benefit has been obtained and when that benefit has been obtained, and also the requisite fault in relation to the obtaining of that benefit by the defendant.
And in terms of that assessment, does that reach the point where an assessment of entitlement or the obtaining of a benefit to which one was not entitled
Exactly, yes.
Involves an assessment of verified income on a fortnightly period?
Yes.
And that reflects the question of entitlement in the Social Security Administration Act?
Yes, that the person was not entitled to obtain the benefit and that the person knew or believed that they were not entitled to the benefit, or indeed were acting dishonestly in relation to the obtaining of a benefit, depending on the offence that was under consideration.
I think you said the Social Security Administration Act, but I think you mean the Social Security Act.
I think I do. Thank you, Commissioner.
No, it's Friday afternoon.
Well, but and also the criminal code. If you're talking about offences, in general terms, the code provisions would be generally preferred.
Yeah, but you've got to start from doors, which is to show that somebody got something they weren't entitled to in the first place, which means looking at the legislation to see what they're entitled to.
The CDPP, though, I take it, had no role in advising DHS about the raising of debts by administrative decisions.
No.
Throughout its business as usual process.
No.
Nonetheless, that was a topic which had come up at some point between DHS and CDPP, as you record in a statement, paragraph 27.
May I refer to the statement,
Of course.
please?
And it might be convenient to bring it up. It is CDPP.9999.0001.0004_R, Exhibit 3990. It'll be brought up on the screen very shortly, Mr. Carter, but at paragraph 27 on the page ending R_0004, you extract a passage, thank you, extract a passage from the 2004 edition of the Social Security Fraud Prosecutions Manual, which was a document in the common use of both the CDPP and DHS.
Yes, that's the passage from the manual. I can't I don't know whether it was in common use by DHS at that point in time, but it's certainly reflecting in the manual the arrangement that we had with DHS, which has been confirmed in various ways in the material that follows in my statement.
What you identify in this paragraph was that at the 2004 conference there was a discussion about the raising of debts for an income support payment based on annualised income, and you identify there that that was information given to the CDPP from the department in circumstances where it seems it had exhausted its powers to obtain evidence in the usual way about the verified fortnightly income.
That's my understanding.
There is a reference here to the role that bank statements might play in terms of identifying at least the dates of payments of income, presumably in net amounts, and the referral back from those net amounts to, I assume, gross figures. Is that right?
The latter step I'm not able to comment about.
Okay.
But it would be a part of the material that would be considered in the individual case. There may be other evidence that bears on the question of the person's employment and their arrangements with their employer.
In this context, the reference there to FACS was the acronym for the department as it was called at the time.
Family and Community Services, as I understand it, yes.
And it says that they have been asked to provide legal advice on Centrelink's ability to raise debts in these circumstances. Is that asked by the DPP?
No.
No. What do you understand that a reference to be?
I understand that to be a reference by, for a request to FACS by DHS, or Centrelink as it was perhaps at that stage.
Right. That is, the request appeared to be an internal one by Centrelink, or from Centrelink, of FACS.
Yes.
Right. You indicate the reference to the question of annualised income and the possibility of Centrelink obtaining legal advice about whether it could raise debts on annual income was deleted from later references or later versions of the CDPP manual. Was that because the question became irrelevant or the advice was never provided to the CDPP? What do you recall?
I don't know why it was deleted. I would have had some involvement in relation to further editions of the manual, but I don't have any recollection about that issue. I have made an inquiry of one of my colleagues and they have no recollection either. But I can say that in our searches to assist the Commission, we have not located any record of receiving an advice in relation to that.
Right. Thank you. And just to complete the topic in respect of annualised income, because it formed no part of the role of CDPP to advise the department in respect to whether or not debts can be legally raised for income support supplements on annualised income, I take it the CDPP doesn't have any information about the extent to which the department was adopting that methodology.
Only to the extent that's reflected in the Centrelink manual, to my understanding.
All right. If I could have Exhibit 4128, CDP.0001.0020.0796. Mr. Carter, this is a DHS and CDPP conference note from 2015. You might be familiar with it.
Yes.
Yes. If you wish to see a hard copy, please say so. I can take you to a particular tab in the two additional volumes which have been placed there, but you might be content with the screen.
Yes, for the moment, thank you.
Thank you. We see your name third in the row at the top.
Yes.
And two persons from the department, Mr. Withnell and Mr. Brown, and this was a conference on the 26th of November 2015.
Yes.
The notes, as it were, or minutes of the conference are set out in following pages, and if the next page could be brought up, .0797, and item 1 and the 2 sub-paragraphs to the centre of the page could be pulled out. Thank you. Mr Withnell gave the welcome address, and what he said has been taken down in short form in the minute. You can see that?
Yes.
And he conveyed to the CDPP that there was a transformation in point 2 I'm referring of what the department was doing as a compliance operation. And the second dot point indicates the rollout of a PAYG income matching program to a significantly higher scale than compliance operations had occurred historically.
Yes.
One of the action items which developed from that conference, if we can go to the last page of the document, 0800, thank you, in the table, action item 1 at the top was that there was an identified need to agree current practice regarding bank statement evidence, and it was assigned to you to propose a practice group instruction which included the way in which that potential evidence would be treated.
That's correct.
And I've been provided with this document a short time ago, which appears to be the result of that action item, which contains your signature, and it's dated 4 December 2015. Is that a document you're familiar with?
Yes.
Commissioner, if I might just indicate, I have additional copies available now.
Thank you.
Perhaps if they could be provided to the Commissioner, thank you.
I don't have a copy.
And, of course, Mr Carter.
Yes, I do have a copy. I beg my pardon.
Commissioner, could I tender that as Exhibit 4128A?
Yes.
You're familiar with that document, Mr Carter?
Yes.
I take it you drew it to our attention
Yes.
directly. Thank you. And that identified really the evidentiary basis and relevance of bank statements in income debt cases.
Yes.
Thank you. Do you recall subsequently any discussions with members of the Department of Human Services about the use of bank statements in terms of proof of fortnightly income in administrative debt decisions?
No. I mean, my understanding goes as far as what's included in the Centrelink manual, right, in relation to their understanding of the position regarding that.
All right, thank you. If I could have Exhibit 4031 brought up on the screen. This is continuing the chronology, Mr Carter, CDP.001.0014.7233_00001. This is a minute from a Centrelink focus group, 20 January 2017. And if paragraph 1 could be called out, including the 2 dot points. Mr Carter, was this a focus group which comprised CDPP members alone or in conjunction with DHS personnel?
CDPP.
Right. And the point that is made at paragraph 1 was the reference to the media surrounding the automation of debts raised by Centrelink at that point in time.
Yes.
January 2017. And that obviously had a potential relevance to income debt cases that were prosecuted or referred to or considered for prosecution by the CDPP?
We were conscious that we were prosecuting on the basis of verified income,
Yes.
and we, from the 2015 conference, were understood that that was a compliance program. It wasn't a program that was relating to the prosecution function.
Yes.
And that was a separate compliance process to the prosecution process, which we understood had very clear requirements in relation to the evidence that was necessary to establish those cases.
Yes. I should have taken you through the point, although you deal with it in your statement. Your reference to verified income is identified by you in paragraph 24 of your statement as ordinarily including evidence of a person's income from employment, usually in the form of a witness statement from the employer exhibiting pay slips or other employment records, and the receipt of income as evidenced in bank statements.
Yes, that's correct, and it may be added to by admissions by the defendant or other evidence potentially.
Thank you. It's fair to say that from January 2017, and indeed prior, but from January 2017 at least, there was a very clear statements by the CDPP to DHS about the position taken that the CDPP would not consider prosecutions which were based on averaged.
Well, the position of the DPP, as evidenced in the 2004 conference minutes, had been a very long-standing position. It had not changed prior to the commencement of the Robodebt scheme, and it did not change during or after that program.
Can I take you to Exhibit 3977? We move now to June 2020, Mr Carter.
Yes.
CDPP.999.001.004_R_0306. This is Exhibit JEC 07 to your first statement, if that helps you.
Yes.
The document, Exhibit 3977, is an email from you to Kate Buggy, B-U-G-G-Y, and another person, copying, I think, various members of the CDPP in.
That's correct.
And it responds to her email. Perhaps if we could just go to the next page on the screen. Thank you. It responds to Ms Buggy's email of 29 May 2020, which relates to the media release of the Honourable Stuart Robert in respect of changes to the income compliance program.
Yes.
And it observes the existence of the class action, which had been raised, I think, by defendants in matters which had been prosecuted by the CDPP.
Yes.
And you sought a list of defendants referred to the CDPP who had been sent a notice of advising them that they were a member of the Robodebt class action.
Yes.
That is, persons in respect of whom averaging may have been used to calculate their debt.
That was my understanding.
Yes. Did you ever receive that list?
No.
You did receive a list which contained, I think, 71 persons who had been identified as potentially being relevant.
Yes.
When did you receive that? Do you recall?
I think that's in my statement. It was...
Sorry, I might be able to find it quickly. It was probably...
Or it was 3 June in para 35 of my first statement.
Thank you. If we could have Exhibit 3998, please. CDPP.999.001.004_R_03111. Sorry, Commissioner, I should say tab 10 in the bundle. It was an email from Mr Clark dated 3 June. Yes, to the next page, please, which contained 3 spreadsheets where there were a total of 71 cases flagged for checking by Services Australia. Did you see that?
Yes.
Did that lead the DPP to conduct an audit, or, in a sense, of those files?
Yes.
A review of them? Yes. Can you just outline that process, please?
The process involved my drawing together experienced CDPP prosecutors, and 2 people were tasked with looking at those cases in detail to ascertain if there was any inclusion of averaged income in the matters that were referred to us for potential prosecution. And the matters were at different stages. Some were before the court, some were in brief assessment, and we were concerned to ensure that that process was undertaken as expeditiously as it could be.
In terms of the context of the information given by Mr Withnell at the 2015 conference, that is the expectation of hundreds of thousands of compliance reviews over the coming years, each year being undertaken, the suggestion of 70 matters which might be touched by averaged income was obviously a minuscule figure.
Well, yes, it's a small number by comparison to that large number, yes.
That is, it illustrates the very significant difference between the process involved in raising debts administratively by the department, of which the DPP has no involvement, and what might flow in the sense of potential fraud cases from that type of review.
Yes, I mean, in the period that the Royal Commission is looking at in those relevant years, my understanding is that we received 3,807 referrals from DHS in its different manifestations. Not all would relate to income, of course. There may be other benefits and other disentitling bases for prosecution action apart from the receipt of income. But that's the scale of the referrals that were referred to the CDPP in the relevant years that the Commission is considering.
In general terms, less than 1,000 a year?
Yes, yes.
And to your knowledge, was that a significant variation from previous years?
There's been a decrease in the number of referrals from DHS, if I can use that as a global term. In 2021, our referrals from DHS were 13%. I think it was 2018-19 they were 18%, and they'd been probably higher than that in earlier years. As there's been a change in the nature of the referrals that DHS has made. They've tended to become more complex. They've tended to become not so focused on income, but on other types of disentitling circumstances. So there's been a change in the nature of the practice to some extent as well.
And when you refer to percentages, are you speaking of the percentage of the total referrals received by the CDPP?
Yes, that's correct.
What about in years prior to 2015?
I don't have that information to hand, but my belief would be that it would be a bit higher, would be higher.
Right. Than
certainly higher than 13%, yes.
Right. You explain in your statement that the process of analysing the 71-odd files was not as clear-cut as might have been hoped?
No, it was difficult to discern from the material that we had whether or not average income had been included. And the material illustrates that we had discussions, our officers had discussions with the department about different cases, and they went through a process of we went through a process of trying to ascertain if any of the matters had been affected, and to the best of our searches at that time, we were unable to ascertain that any of those 71, and then one matter was deleted, so it was 70, were affected by averaged income.
And was that inability to determine whether those referrals were affected by averaged income due in part to the way in which the information was presented to the CDPP by DHS?
That wasn't apparent to me at the time. That was apparent to me in terms of the review that was subsequently conducted in preparation for our assisting the commission with material, and we discovered three matters that were affected.
Can you describe to the Commission the renewed review or audit in terms of preparation for your evidence here?
It was similar to the first, but I think it was with the benefit of a much greater appreciation of potential indicators that might be there. But that said, in relation to one matter that I suspect you'll take me to in due course, it was not easy to discern, and it relied on understanding a note to a debt schedule in relation to a portion of it, or to a debt that had been included with another debt, had been amalgamated with that debt. And so any feature of uniform figures, for example, in terms of averaging, was not apparent. And nor was it brought explicitly to the CDPP's attention that averaging had been included within the referral.
The case that you're talking about, was that the one that was recently identified and is set out in some detail in the supplementary statement?
No, I was referring to the case of RM, which is referred to in my first statement.
In the first statement, yes.
But I would make the similar point in relation to the case of GB that's addressed in my further statement, and also two other matters that were identified on the further review of cases in 2022.
Yes. Does that lead you to the point where you can't be certain that prosecutions referred to the CDPP by DHS during this period did not rely to some extent, in some cases, on averaging?
The CDPP has undertaken considerable researches in relation to seeking to identify cases, and as I've said, we've located several matters that were not located in 2020, and the position is that in some cases it may not be possible, in my view, to discern from the material that's been provided to us for prosecution on the basis of verified income, that there may not be some component of averaging in part of the process that's been involved in the calculation of the debt. And that's apparent from several matters that we have received where we've had no sense at all that there was any element of income averaging involved in the matter until we've been informed by DHS that the debt's been overturned or it's under review, and therefore we've been put on notice in relation to that. And the point that I'd like to make in relation to this is when it has been apparent to the DPP that there has been income averaging, in all of the cases that we have identified, the appropriate steps have been taken, the income has been excluded, and the matter has been prosecuted on a reduced debt, or indeed in one instance, the balance of the debts was such that it was determined that prosecution wasn't in the public interest. So appropriate steps have been taken. When it's been apparent to us that a case has involved an element of averaged income, and in all the matters that are referred to in my statement, it has been the case that it has been a portion of the referral that's had that character.
As I read your statement, you have not in your audit identified any shortcoming in the diligence of prosecutors in the conduct of prosecutions or investigation or their review of investigations, but it is the form in which information is presented to the DPP which clouds the issue.
Yes, look, I have to recognise, and I do, that in one instance it was picked up on an appeal by the defendant. I'm pleased to say that it was picked up before the finalisation of the appeal, but that was at a late stage in the process, and it was picked up and drawn to the case officer who was conducting the appeal's attention, and the appropriate steps were taken, and the debt was recalculated in that instance on the basis of verified income. And as it turned out in that matter, there was a very little difference between the two. It was $1.14 was actually the difference between the two calculations. But of course, that's dependent on the facts and circumstances in the particular case. In another case, it was picked up at the sentence stage, and the matter was accordingly dealt with on the reduced debt. And as I've said, there was another matter where it wasn't proceeded with at all in the public interest.
The matter which is identified in your supplementary statement, GB,
yes.
I think it was picked up after charges, I think 10 in total, had been presented in the Magistrates' Court, and information came from DHS that the administrative debt had been reduced substantially upon a review requested by the defendant.
Yes.
That is, the debt went from approximately $13,000 down to approximately $200. That is one of the debts.
I believe that's the case, yes.
There were two other debts that were, perhaps if I deal with global terms, two other debts that were the subject of a number of charges, as I understand it. And the indication from the department was that although reviews had not been initiated or maybe were about to be initiated, they were infected, as it were, by the same difficulty with averaged.
That was our understanding, yes.
Yes. And that, as you set out, led the CDPP to consider that there was no public interest in the prosecution of the debt, which was likely to remain of approximately $200.
Yes.
But again, that was a matter which wasn't able to be identified on the material, I take it, referred to the CDPP.
That's our view.
Do you know how the state of the material you get from DHS compares with what you might see if you lodged an FOI application as a recipient? Is there any comparison? Are you looking at the same sorts of things? I'm just thinking, if it's hard for your lawyers, what's it like for somebody with a debt?
Well, I'm not sure I can comment because I don't know what material would be at the other side, if you like, in terms of the civil processes within DHS. But I think, the material that we receive, we receive a brief submission which sets out the allegation and the basic features of the case, and we receive a debt schedule that sets out the income that's been received and the entitlements, and that then leads to the debt that's asserted by...
Is that the same thing as an ADEC schedule, do you know?
Possibly, I'm not sure, Commissioner. And there's various material behind that in terms of printouts from screens and so on that would support the case. But in our analysis of referrals for the purposes of assisting the Commission, we've only identified one matter where the CDPP was informed directly that, I think the term apportioned was used rather than annualised, but that was actually put in the brief referral. And the matter was immediately identified by the CDPP and wasn't prosecuted on that basis.
That is, in only one occasion has it been identified by your office that despite the continued position about the DPP approach, that averaging or apportionment was expressly identified.
Expressly identified, yes.
Are you aware that within the department there is a section called the Serious Non-Compliance Unit who initiates the investigations and ultimately refers the brief to the CDPP?
Yes.
Based on your experience, including your involvement in the audits and reviews and your preparation for giving evidence here, are you able to say anything about whether there is a sense of awareness in the Serious Non-Compliance Unit within the department about the significance of averaged income in the context of prosecutions?
Well, yes. I mean, it's been a consistent position since 2004. It's reflected in material that I've produced in relation to the notice, into my statement, in terms of best practice guides and so on that are in the department. It's very clear where it says that evidence should be excluded in a referral to the CDPP. So there is a clear understanding reflected in those documents in terms of the civil process and whatever the view might be in terms of the legality of using averaged income in that context and what is required in a prosecution context. And of course, it also falls against the backdrop of our discussions that you took me to in 2020 in relation to seeking to ascertain matters referred. And the fact that there have been instances where there's been discussions in relation to several cases since 2020, and that's set out in my statement, in terms of then having to consider the impact of averaging that's been identified as pertaining to one of the matters, to a matter referred to us.
In terms then of the systemic question, that is how matters are being referred by the Serious Non-Compliance Unit to the CDPP, which involve averaging contrary to the better practice guidelines and the clear position of the CDPP. Can you say anything about that?
Pardon me, can you repeat that question, please?
Can you make any observations or give any insights as to why matters might be referred to the CDPP which involve averaged income or apportioned income despite the CDPP's clear position?
Not really. I mean, we've produced material to the Commission in relation to our ongoing liaison with the department and our centralised correspondence arrangement with them, where they put together our advice in relation to many issues and issues in relation to brief referrals and so on. So this formed part of our understanding with them about what the position was from our perspective. And in terms of your asking about essentially whether it might be systemic or something like that, I think is the sort of drift of what we're talking about here. There were two matters in the centralised correspondence reports in this period, and I was, I can't recall having a direct recollection of those reports, but I may well have seen them. And certainly that number of matters and the number of referrals that we've received were not such that gave rise to my concern that there was some systemic issue in relation to the referral of annualised income to the CDPP, but rather there's been a non-compliance in relation to that requirement in a limited number of cases. And indeed, the work that's been done to prepare for the Commission, the documents, has indicated that there's a relatively small number of matters, as we understand it at this point in time, subject to the qualification that I made earlier, that have been affected, and only one matter has proceeded to finalisation in the criminal prosecution process on that basis, as we understand it.
Commissioner, that was the extent to which I wish to ask questions of Mr Carter.
Thank you.
Nothing arising, Commissioner.
All right. Mr Carter can be excused.
Yes, he can.
Thank you very much.
Thanks, Mr Carter. You're excused. That's it for the day.
Yes.
I'll just put on the record that Mr West was unwell today. I should never have let him go, Ms Hogendorf, and I shouldn't have listened to you.
Is it my fault that he went back to Canberra?
Yes, I think it might be. Anyway, back next week on Monday.
On Monday, yes. Thank you, Commissioner.
Adjourn till then. Thanks.
All rise. The Commission stands adjourned until 10 a.m. on Monday.